They had another location out there. Court does call the case, People versus Mohammed Diane. But before we begin, I think I need to waiver.
Good morning, Your Honor. Ali Zed on behalf of the people. Your Honor, the people will waive any potential conflict between the Honorable Court and the Office of Public Defender. While the people don't believe such conflict exists, the people make this waiver in avoidance of all harm, Your Honor.
Thank you, Your Honor. Assistant Public Defender Natalie Pate on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this Honorable Court and our office. However, if a conflict were to wherefore arise, we would waive such a conflict.
All right. And the court, for its part, also does not believe there's conflict either in administrative court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. State of Michigan versus Deanne.
Good morning, Your Honor. This is Amber Gary, your coastal judicial practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ali Zed.
Permission to practice is granted.
Thank you, Your Honor. This is Amber Gary, people.
All right.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Muhammad Jinan, who appears via Zoom from MDOC. Sir, could you please state your name for the court?
Do we have him?
So they're there, their camera was on, they are unmuted, but now their camera's on.
Mohammed Deanne?
Yeah.
I don't have a photo. I don't have a picture.
He is on. And he is.
Mr. Deanne, if you can hear me, please state your name. I don't have a photo. I'm blank.
Yeah, I can see now. So
I'm going to pass that matter.
Thank you, Your Honor.
Court does call the case of the People versus William Parker.
Ali Zed on behalf of the people, Your Honor.
Yeah, good morning, Tom Piotrowski, P40021 on behalf of Mr. Parker, who is in court today, standing to my right. Mr. Parker, identify yourself, please. Yeah, my name is William Parker.
All right. What are we doing?
We are pleading per the people's offer of operating while visibly impaired second, with the understanding that Mr. Parker will be going into sobriety court as well.
So he's pleading to an added count to operating while visibly impaired second.
Yes, sir.
Correct.
Do I have a plea form?
Yes, sir, you do. Along with the advice of rights.
So the advice of rights, I just. Got it. You see, it was turning the other way. All right. Court's understanding is he's going to be pleading guilty to the charge of operating while visibly impaired second offense, a 1-year offense. Upon a successful plea to that charge, count one would be with full understanding.
Yes, sir.
May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Lower and then state and then spell your name on.
Yeah, William Parker, WILLIAM and PARKER.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you?
I'm sorry.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not currently, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of February 5th, 2025, at the location of, and I've got the wrong, Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had 4 drinks and 1 shot, Your Honor.
Okay, 4 drinks of,
Beer.
all right. Were you stopped by the police or was there an accident?
I was stopped.
Why'd they stop you?
They said I was weaving a little bit.
Okay. Are you disputing at all or contesting the right of the police to stop you in this case?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital for a blood draw?
Yes, I was.
All right. And what were the results of that blood draw?
I think it was 0.12.
We'd stipulate to that, Your Honor.
0.129.
0.29. Yes.
And so you have no reason to dispute those blood test results?
No.
All right. And sir, taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. And prior to that date, on or about October 19th, 2022, in the 48th District Court, had you been convicted of operating while visibly impaired?
Yes, Your Honor.
All right. Sir, before I accept your plea, I do have to advise you that if I accept your plea between the time of today and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any evaluation or sentencing recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir. No, sir.
Have I complied with the court rule, and would it be proper to accept this defendant?
Yes, sir.
Yes, Your Honor.
All right, court will accept the defendant's plea to count two. Count one is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be. Is he trying to get into a sobriety course?
Yes, and he already has been assessed, Your Honor, by Crystal Rays.
So 14B.
Yes, sir.
All right. Talk to probation as to how they want to handle that. Sentencing in this matter will be
August 27th at 12 p.m.
August 27th, 2025,
Can
12.
we make it the following week?
I don't know, sentencing is the following week. What's the
So
September 10th would be,
Yes, sir. Thank you.
that work?
Yes, sir. It's 9/10, September 10th.
September 10th, 2025, 9 a.m.
Yes, sir.
Bond with its conditions will continue.
Thank you, sir.
Thank you.
thank you.
Court does call the case of the people versus Aline Wood.
Wood?
Ellie Zinn on behalf of the people, Your Honor.
Good morning once again. Tom Pietrowski on behalf of Mrs. Wood. Mrs. Wood, if you would identify yourself, please, and state your name.
My name is Aileen Jane Wood.
All right. All right, what are we doing?
I've
This
had,
is an arraignment.
I think, pretty sure she may have been already arraigned and maybe not. We'd waive arraignment if so.
Wait, formal reading to stand mute.
Yes, sir.
Defendant having waived formal reading, standing mute, court will enter not guilty plea.
We're in contact with Ms. Londy. We're trying to resolve this, and also we're waiting for additional discovery, some medical records that I've requested. So we just ask for an adjournment, Your Honor.
It's 6, right?
Excuse me?
Yes. All right. Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to
September 3rd.
Can we have it on the 10th as the other cases, Your Honor, or not? No? Okay. September 3rd it is.
pretrial will be adjourned September 3rd, 2025, 9 a.m. Or as your invite indicates, as to bond in this case,
Would ask for a personal.
set the defendant's bond as a personal recognizance $5,000 bond. There is, I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's no use of alcohol, recreational marijuana, or any illegal drugs. That's all I'll do at this point.
Thank you, sir.
Thank you.
Thank you.
Court does call the case people versus Jason Elk.
Ellie Zinn on behalf of the people, Your Honor.
May have pronounced that wrong. Now get Mr. Diane back.
I have not heard from the facility yet, but I did. Look at their assistance.
Good morning, Your Honor. Robert Goldman, P81222, here on behalf and alongside defendant Jason Eckel. Mr. Eckel, would you please state your full name for the record?
Jason Michael Eckel.
As to the arraignment,
Your Honor, for purposes of the arraignment, having had the opportunity to discuss the matter at length with Mr. Eckel, we are prepared to waive a formal reading of the complaint. Mr. Eckel will stand mute. We ask the court to enter a plea of not guilty.
defendant never waived formal reading, standing mute. Court will enter a not guilty plea at this time. What are you requesting I do with this?
Your Honor, for purposes of pretrial, we would be asking the court to set a pretrial date in this matter to give opportunity to further engage in due diligence and discussions with the prosecutor's office in an effort to resolve the matter.
Pretrial in this matter will be adjourned to
September 3rd.
September 3rd, 2025, 9 a.m. As to bond in this case, alleged BAC.
Your Honor, I have in my notes as a 0.09.
Are there other
0.09 and then a 0.10 after on the chemical. So 0.1.
point one? And this is a second offense.
Correct, Your Honor, there was a 2021 prior.
Any accident?
No crash in this case, Your Honor.
No injuries either, Your Honor.
Set the defendant's bond, $10,000 personal cognizance bond. All other standard conditions, including no assault behavior, possession of any weapons. You are now at this time not to possess or consume any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes, Your Honor.
I am also going to order that he report over to the Department of Community Corrections for placement on a SoberLink testing device. And I have signed that order.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Janine Kruger.
Allie Zend on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Ms. Kruger. Ms. Kruger, unmute and state your name, please.
Janine Kruger.
Okay.
Your Honor, in this case, we adjourned to today so that the people could reach out to the complainant to see if some of the references in the police report are still true about a desire to proceed. That is not resolved yet. So we're asking to adjourn the pretrial one more time.
You're in pretrial in this matter, September 3rd, 2025, 9 a.m. Bond will continue. All right. Thank you. Court does call the case of people versus Jillian Satori.
Allie Zend on behalf of the people, Your Honor.
Your Honor, Joe Simon on behalf of Ms. Sartori. Your Honor, I'll state your name, Jillian, I'm sorry.
Jillian Sartori.
Thank you.
We're here for a couple of reasons. One is to address the bond violation. The court wanted levels. The parties didn't get the published levels that I think the court has in the court file. But from my understanding, she is in fact coming down on her THC levels.
Yeah, kind of. I think this is the one that I was thinking of. I think what happened is he went. My last one. It's just the last one. They're backwards. Got him. Yeah, she went up and then decided to come down. So she is coming down.
Well, Your Honor, we don't have what you have, but she's been very adamant that she's been following your orders. So,
all right.
And the other thing is Ms. Lonnie was not prepared to make a resolution until we knew that answer. So we're going to ask the court adjourn this pretrial, but maybe we approach on one other thing real quickly.
Very quickly.
Thank you. I don't move too good today. Thank you, Your Honor.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. David Shan on behalf of Brandon Bovee is approaching. Brandon, can you please state your name for the record?
Brandon Bovee.
I believe this is arraignment and pretrial, Your
Yes,
Honor.
sir.
So we'll waive formal reading. Defendant will stand mute.
Defendant every way formal reading standing mute. Court will enter not guilty plea.
Your Honor, we don't have any discovery in this at all, so we're going to have to adjourn it. And I also have another wrinkle, but we can address that with bond as well.
Pretrial in this matter will be adjourned then to September 3rd.
That's the wrinkle.
Okay.
This is a second for him.
Yes.
He lives in Lenawee County
Where?
in Deerfield.
Lenawee County?
Yes.
Sorry to hear that.
I
No, go ahead.
Middle of nowhere.
because of this is a second, he will qualify for sobriety court. And Judge Shadler, I do an open talk for her every year, her graduating class, she owes me. So I would like,
Wow. Wow.
she does, 9 years in a row, she owes me.
Wow. I know.
She
Yo,
does.
you had to
It's-
I want to see, as soon as I heard that, I turned around because I want to see that conversation.
So we're going to need more time after
you
that.
have to calm down.
I know.
Yeah, so you owe him.
She told me herself that she owes me, so I'm not speaking out of school.
Okay.
But I think we're going to need the next available date in order to make sure that he qualifies, get him screened and assessed, have the plea entered here, and then be able to transfer to there. So if that's whatever the next available date is after the 3rd of September.
After the 3rd, September 17th,
That would be wonderful.
2025, 9 a.m. or as your invite indicates. Alleged BAC in this matter?
Your Honor, it was a .129.
Okay. He has a prior on this.
He had it first a couple of years ago. So
And the prior was 2021, Your Honor.
Got it.
it has to be released in the PR bond. I know you're going to order SoberLink and he would be fine with that.
Bond will be set in the amount of a $15,000 personal recognizance bond. All order standard conditions, including no assault to behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You are to report over to the Department of Community Corrections for placement on a SoberLink testing device. Thank you.
Right here, I'll take it. Thank you, Your Honor.
Court does call the case, People versus Eric Casey.
Ready, Ron?
And then on behalf of the people, Your Honor.
Good morning, Rob Jacob on behalf of Mr. Casey, who's approaching the bench. Eric, would you state your name?
Eric James Casey.
Judge, we have continuing possible settlement negotiations with Ms. Londe. I'm asking for an adjournment.
Adjourn the matter to September 3rd, 2025, 9 a.m.
Thank you.
The bond will continue. Thank
I
you.
want to say also, I want to thank you on, if you remember Tanya Hall, thank you for recalling the warrant.
I did that.
You did that. You're the kind and considerate judge I know.
And tell him you're welcome. Anyway, court calls the case, People versus Jennifer Gallara.
And then on behalf of the people.
Good morning, Marissa Boyles, P86438 on behalf of Ms. Gallara. Will you state your name, please? Jennifer Gallara.
All right. As to the arraignment on this, you wait for more reading. Your client stands mute.
Yes, Your Honor.
Defendant every way for more reading, standing mute. Court will enter a not guilty plea. What are you requesting? I do need an additional pretrial date.
Yes, please, Your Honor.
Pretrial will be adjourned in this matter to September 3rd, 2025, 9 a.m. or as your invite indicates. Then as to bond, alleged BAC in this matter.
Your Honor, I have as a .187, and this is a first offense.
It's 0.187.
Correct.
All right. Any accident?
No, Your Honor.
Set the defendant's bond at a personal recognizance $20,000 bond. All order standard conditions, including no assault to behavior or possession of any weapons. You understand that, ma'am?
Yes, Your Honor.
There's also not to be any possession of any alcohol, recreational marijuana, or any illegal drug. Do you understand that? The level in this case, I am going to order that you report over to the Department of Community Corrections for placement on a SoberLink testing device. We're going to do that within the next 24 hours. And probably would be your best bet to head over there right after this hearing.
Yes,
Okay. And I've signed that order. Anything else?
no, Your Honor.
All right. Thank you.
Thank you.
Court does call the case of the people versus Robert Stevens.
Mr. Stevens is or not, Mr. Michael Gaddy is attorney. Private attorney. Mr. Lauren Brown. So you can see any reason why.
So I don't know. What do you mean?
Mr. Gaddy is listed as the attorney of record.
I see that.
Mr. Lauren Brown indicated that there's no reason the PD should have to conflict act.
So it's a PD case.
But Mr. Gaddy is the attorney of record as now. The first time is. I'm sorry. I don't believe Mr. Gaddy.
Well, if he's appearing in his own personal capacity, I don't, the PD, that doesn't help me. Do you know where Mr. Gaddy is?
No, Your Honor. I think he might honestly be off this week, but don't quote me on that.
That he may be off, but he's listed personally as the attorney of record. And not the PD's office.
Yes, Your Honor, that was my understanding.
I'll adjourn this matter September 3rd, 2025, 9 a.m. Court does call the cases of the people versus Rick Artuso, 3 cases.
And on behalf of the people, Your Honor.
Public Defender Natalie Pate on behalf of Mr. Rick Artuso on the cases ending in 1656 and 1657.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso as to the remand.
Mr. Artuso, can you turn on your camera and unmute and state your name?
Rick Artuso.
Turn on your camera.
I'm trying to figure out how to do it.
Zoom started yesterday.
Yeah.
Anyway.
I'm trying to figure out how to do it. I gotta.
Your Honor, I can say that it's definitely his voice.
Yeah.
He's got it.
Yeah. Okay.
All right. So what are we doing?
Your Honor, there's a few pending matters, one's at circuit at this point, and we're trying to, and the prosecutor's office did mention some potential other charges, but they weren't sure that they were going to come in. So we're trying to globally resolve them, I guess, in a nutshell, Judge. So I was just going to suggest we adjourn the pretrial out so that we can resolve it most likely at the circuit court case with these cases following. So
I was going to respectfully request an adjournment as well, Your Honor. There is an offer to resolve both of these 2 misdemeanor cases that I did attempt to reach Mr. Artuso to discuss, but I do need to relay that offer to him. So I'd be correct requesting an adjournment.
Okay. And these other cases, when is the next circuit court pretrial date? Do you know?
1 second. Sorry. Believe it's this afternoon. I think it's this afternoon.
Oh, it's sometime soon.
It's this afternoon at 1:30, Judge. That's why I couldn't remember the date. Sorry. Yeah.
Okay.
It's Judge Hamoud, but yeah.
Hamoud will be hearing it. But the okay. And then these other cases.
Mr. Emmons, I was told, Judge, that we're not sure about, he was checking to see if they were going to charge them or not. And I see.
There hasn't been any charges authorized on those, so I'm not sure who's currently reviewed or if they're being reviewed. So I can take a look at those.
All right. During this to September 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Thank you, Mr. Artuso.
Okay, thank you.
Court Court does call the case of People versus Nicholas Stemmel.
People.
And good morning, Your Honor. Rita Young, P44626, appearing on behalf of Mr. Nicholas Stemmel, who is also on Zoom. Sir, could you state your name for the judge, please?
Stemmel.
All right, very good. What are we doing?
Judge, we're asking for a final pretrial date. Try to see if we can resolve this matter.
You don't want to do this Friday. I'm taking it. I should said it this Friday. We haven't seen you in forever, Miss Young. Make you come down here. But I'll give you the October dates.
You're so kind.
Jury final settlement conference will be October
17th.
October 17th, 2025, 9 a.m. Jury selection, if necessary, will be October 20th, 2025 at 8:30. Both of those proceedings are in person.
Okay, thank you so very much.
Thank you. All right, take care.
Likewise, Judge, can I hear who the prosecutor was? I didn't hear her name.
She doesn't have a name. No, I'm kidding. The prosecutor actually assigned to it is Miss Landy.
Okay, thank you so very much, Judge.
Thank you.
Mr. Stemmel, you can zoom out now and I'll be in touch.
Okay, thank you.
Court does call the case, People versus Abdallah Bader.
Christina Verzarian for the people. This is
Arraignment pretrial without counsel. And I already issued an order to show cause. What? Was it set aside? Pardon?
I have.
It had to be. Bench warrant will issue for the defendant's failure to appear in this matter. Bond will be set at 10,000. 10%.
Thank you, Your Honor.
That warrant will issue immediately. There having been a previous warrant as well as show cause. Court does call the case of the People versus Christopher Banks.
And then on behalf of the people, Your Honor.
An Assistant Public Defender, Natalie Pate, with and on behalf of Mr. Banks, who stands to my right. Please state your name for the record, sir.
Christopher Banks.
Excuse me. Thank you, Your Honor. I'm respectfully requesting an adjournment. I did reach out to the people regarding this. We don't have any media discovery yet, and I believe it does exist based on police report references. So I'd be asking for one adjournment or another adjournment.
September 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Court does call the case, People versus Alexis Berry.
Christina Verzarian for the people.
Sorry, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Ms. Berry, who is appearing via Zoom. Can you please state your name for the court?
Alexis Berry.
All right.
Thank you, Your Honor. I am requesting an adjournment in this case. Ms. Landy did make an offer before she went out to an operating while visibly impaired second, and I did discuss that with my client. There is some other mitigation information and things I'd like to discuss with Ms. Landy regarding this. To my understanding, my client is completely compliant on bond as well as her current probation. So I'd be asking for an adjournment into the September date.
September 17th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Ms. Berry. Thank you, Your Honor.
Thank you.
Thank you. Court calls case, People versus Grace Bonilla.
People, Your Honor. Christina Raven, pretrial without counsel.
Bonilla, no response. I'll issue an order to show cause. Court calls case, People versus Michael Bork.
Christina Verzarian for the people.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Burke, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Yes, Michael John Burke. Morning.
Good morning.
Thank you, Your Honor. I'm respectfully requesting an adjournment. Ms. Landy did indicate to me that there would be no offer in this case, and I do need to further discuss that with my client.
September 17th, 2025, 9 a.m. Bond continued.
Thank you. Thank you, Your Honor. Thank you, Mr. Burke.
Court calls case, People versus Matthew Bullard.
And on behalf of the people, Your Honor.
Issue an order to show cause. Courthouse case, People versus Zachary Burlett.
And then on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlett, who appears via Zoom. Sir, can you please state your name for the court?
Zachary Burlett.
Thank you, sir.
Thank you, Your Honor. I have discussed this case as well as the discovery with my client. We're asking for an adjournment so that I can speak about some mitigation information with Ms. Landy. This is an older retail fraud case from alleged incident date from over a year ago. Mr. Burlett's currently on probation to this court. He's doing very well in transitional housing. So I'm just hoping to talk to Ms. Landy
He's
about it.
transitional at this point.
He is through Dawn Farm, Your Honor.
So let me adjourn this out to September 17th, 2025. He's on probation. How long have you been on probation to me?
Since June 11th of 2024.
Okay. That's what I thought. I knew it had been a while. So I'll go up September 17th, 2025, 9 a.m. How are things going otherwise?
Everything is going great. This player has been very supportive. Still, being the service in the community, still learning, just taking it day by day.
There you go. All right. Well, I won't tell Miss Polera that you said nice things, so, okay? All right. Burlett, you take care.
You too. Oh, wait, really quick. Do I have an upcoming review here soon?
On the other case?
Yes, I'm on a probation.
You'll have to contact probation. I don't have that information in front of me because I don't have that case in front of me.
I'll call her and tell her things and find out.
Okay, I'm gonna tell her you said bad things about her, but don't worry about it. I'm gonna get to her first. We'll see how that conversation goes then. All right. All right, Mr. Burlett, you take care.
Bye.
Thank you, Your Honor.
Court does call the case, People versus Deaja McCoy.
And then on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Deaja McCoy. Respectfully, Your Honor, I did, you notice I tried to walk up slow.
Yes, I did. I did. They're gonna take all day. Okay? I'm like,
I was trying to buy myself 5-10 minutes. My client did say she was about 5 minutes out when I just stepped out.
How long ago was that?
About
half an hour.
A minute and a half ago.
Oh, right.
No, right when I stepped out and came
You
back.
were in here a minute and she didn't tell you.
That's when I came. You seen me go out and come in. I've been here about 72 seconds. Maybe 93 seconds or so. She did.
So she told you she'd be here in 5 minutes.
Yep, she said she was 5 minutes out.
Okay, was that a real 5 minutes or how soon are you gonna be here? Give me 5 minutes.
I know about 22 minutes ago, she told me 20.
Okay.
But I heard her car. I heard her.
I'm done. Third, I'm done. I'm done. I'll pass it. We'll call it up at the beginning of the next block.
Okay, when's the next block start? Yeah.
Your client is not here, and now you're gonna pressure me for when does it start?
I just wanted to know about
time for breakfast. Inconveniencing your day?
No, I just wanted to know if I had time for breakfast. That's all.
Well, what kind of breakfast you gonna have?
McDonald's.
Go, because I've seen you when you don't eat, and it's gonna be a mess. All right.
All right. Thank you.
Okay, you'll have enough time.
Appreciate it.
If he goes to the McDonald's in Canton, I'm sending police. There are 2 McDonald's within 3 minutes of here.
Left, right out here.
You can go left or right.
Okay. I'll go either one. Right?
Well, there are 3 right around here.
Gotcha.
Okay.
All right. No,
don't get lost.
I won't.
Okay.
Thanks.
What are you gonna get?
Sausage, egg, and cheese, combo, add biscuit, egg, and cheese.
Wow. Okay. Enjoy.
Oh, yeah, just like
I want that too. So that's a lot he's gonna eat. He's gotta come back here napping. Have we been able to get through to Mohammed?
I have not received a response from the NDOC regarding the complaint.
Mohammed Diane? Okay, counsel, on Deanne matter, what I'm gonna do is I'm just gonna adjourn this out to September 3rd.
May I make a request, Your Honor?
You're going to anyway.
Pursuant to that law, 2925, let me get the statute, because we don't ever do it. 292915B. I am going to continue you on community control, and I'm going to send you to prison for a period of 90 days. So you're going to the pen, and you're going to get out right before Thanksgiving and Christmas, when there is ample opportunity for you to want to get back into your child's life. And I want you to do that. But I want you to do that under the strict requirements that go along with that. And if you're thinking to yourself, you know, I really want to do this, or I really want to send somebody a message or whatever, you need to not do that. Because I think that my role in this, as distasteful as I find it to be, is to try to manage the situation, because I have a bigger stick than the boys over in juvenile court and the boys over in family court. Because if you violate this again, you know what's going to happen is that the little 90-day window that you get of prison is going to be a lot longer. So wait, I have to do some math here. Hold on. So I'm going to sentence you to 72 days of jail and an additional 90 days in prison. And that 90 days will start today. So we're going to set this for a hearing in whenever it is that you get out, for a probation review hearing, so that we can figure out how we're going to get things back on track. Yes, ma'am?
Can I speak, please?
What do you want to say? And be very careful what you say to me.
I will. Do I get to come up to the podium?
No, just what do you want to tell me?
I'm Brandon's mom. And
I know, I recognize you from the jail calls.
I figured. And I just want to say, first of all, Your Honor, you are in a very tough position. Everything that you're saying, I worked in the courts for 14 years in Butler County. I watched people go to prison that shouldn't. I watched people walk out that should not have. I worked in conjunction with children's services. So I've been in courtrooms many times. You are in a tough spot. And it's sad that it had to come to this, because this is, I mean, you're in a tough spot. You really are. And I just want to say that I haven't always held Brandon accountable. I've always put a pillow there, and he'll tell you that, up until about 7 years ago. 7 years ago, my son changed his life. He quit doing illicit drugs. He started focusing on his career. Yeah, he still had some mental health stuff to work out. He has severe trauma and loss, and tons
But
of
ma'am,
things.
you and I both know you told him on these calls, you need to knock this off.
I did. I didn't say knock this off. That's not my verbiage. I said it needs to stop. But Your Honor, you are in a tough spot, because there's so much you don't know. And he does want to be a dad to Cruz. Does he still love Lindsay? Probably always will. It's the mother of his son. You know? Does
Yeah,
he want to help
ma'am, I mean, I don't want to cut you off, but I'm going to cut you off, because this is what I'm doing. And I'm looking forward in all of this to the post 90-day prison sentence. I know that everybody tends to be like, oh, you're going to be gone for 90 days. That's going to be trouble. I'm trying to figure out a way so that you and Ms. Hoff can get into some good habits, and that you can do better. And if you do better, then you're going to remain on probation, and there's not going to be any more of this nonsense. If you don't, then it's a math case. I'm going to figure out how long I can send you to prison for, and I'm going to send you to prison for every possible day that I can, because that's the only way that it's not for your benefit, it's not for your child's benefit, it's so that it's punishment. And if you don't do the things that you're supposed to do, which you know what you're not supposed to do, and you do it anyway. So that's what we're going to do. I'm going to continue you on probation. I'm going to give you credit for the 72 days that you have already done. We have an additional 90 days in prison. And so we'll set this for a hearing, which is going to be in about 90 some days. So you'll go, you'll do your prison, you'll come back to the county jail. We'll have a hearing to release you back into the community on, I don't know that it makes sense to put him on a monitor because monitor is not really going to help.
No, I agree. I don't really see that.
All right. What else?
Nothing further.
All right. You do have the right to appeal this, Mr. Wells, to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they will all be provided to you at no charge. And the hearing is over. So everybody on this side is going to stay. Everybody on this side is going to go ahead and clear out so that we don't have any incidents in the hallway. All right. That's all. I'll see you in 3 months, Mr. Wells.
Kyron Crotchery did while being confined at a detention facility with intent to annoy, harass, threaten, or alarm another, cause or attempt to cause another to come into contact with blood, semen, urine, feces, or another bodily substance by throwing or expelling that substance at the other person. This was a corrections officer, Your Honor, that he, during an attempt to place him into handcuffs, he turned around and spit in her face.
Mr. Gibbs, anything on those facts?
Nothing further, Your Honor.
Mr. Cotchery, did you hear the statement that she read?
Yes.
Do you admit and acknowledge what she said was true?
Yes.
And again, you understand all the rights you're giving up, entering a plea of guilty, the rights we discussed?
Yes, Your Honor.
What is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. And based upon the statement of facts and your plea, the court will make a finding of guilty. Ms. Tranter, anything before I sentence him?
Nothing further, Your Honor.
Mr. Gibbs.
Your Honor, I would just like to note my client had not had, to my knowledge and understanding, did not even know the correctional officer, the victim in this situation. He has noted to me his very apologetic about this. He was in a bad place and was lashing out and sincerely regrets his actions.
Thank you. Mr. Cotchery, anything you want to say?
Yes, Your Honor, I just want to say that I apologize to you for having you here today, for you going through this case, and I like to apologize to the victim, but she's not here, and I didn't mean that. Just going through things, and yeah, I'm not that type of person, so I apologize.
Okay. All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court also has considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So I will order you to serve 6 months in prison, that to be served consecutive to your current sentence. The consecutive sentence is necessary to punish the defendant. It is not disproportionate to the conduct of the defendant. And this offense occurred while the defendant was already incarcerated in the Department of Corrections. You got 0 days jail time credit on this offense, and the court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to discretionary post-release control, which we just spoke about. Do you want me to go over that with you again?
Yes.
And again, you have, on your current offense that you're serving on, you have mandatory PRC. This one's discretionary. The adult parole authority may supervise you for up to 2 years on this offense. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of the 6 months or 3 months.
Okay.
If your violation is that if you go out and commit another felony while you're on PRC, when you're in that court, that judge can add time to your maximum sentence in that case, consecutive, based upon it could either be 1 year of additional time or whatever time left of the 2 years you have left on PRC. He can add that to your sentence, so it'd be served consecutively. Okay.
Okay.
So that's what the PRC is. Okay. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal this court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Do you have any questions for me, sir?
Your Honor.
All right, best of luck to you, sir.
Thank you, Your Honor. Good luck, man.
Go ahead.
Could it be past that date? So I applied to visit him in Praga.
Got it. You've got to get in. You've got to get, yeah. Will the 17th, you think? Give you enough time? Probably not.
It might not be very frank, Your Honor. I'm not optimistic that that would be enough time. It might be.
Why? They don't have you on the list?
No, I applied.
Because you're like suspicious, aren't you?
Maybe, if that's what they.
That's why.
I was all ready to go in person to the U at this point, but now he's not there, so. I apologize.
October 1st,
That'd be great. Thank you so much.
2025, 9 a.m.
Thank you.
Miss Perrin, that's you to show up. I mean, good morning.
Good morning.
How are you doing?
I'm doing well, Judge. Thank you for asking. How are you?
I'm doing great. You said, what's his name to get breakfast? For what? He's not gonna bring enough for all of us.
I was gonna
What kind
ask
of
him for
breakfast?
Happy Meal.
Huh?
McDonald's. He's going to McDonald's.
He's going to McDonald's. We don't know which McDonald's he's going to.
Mr. Bird. That's a good McDonald's over there. It is. Mm-hmm.
As opposed to the bad McDonald's?
Okay, I live by a horrible McDonald's.
Me too.
Same here.
Okay, let's broadcast that to the world.
It's
All
I
right.
will. It's like, it takes forever. They never have anything you want.
This one's.
You seem a little bitter,
It's
Tierney.
so close to my house. So easy to go get a Happy Meal for my child when he's.
Oh, now you're bringing the kids in.
But I can't.
All right.
It's horrible. I avoid that McDonald's.
Okay. All right, I'm gonna stand in recess. You need to calm down in the interim.
Okay.
All right,
Okay.
and I'll come back and we'll start the next block. Court stands in recess.
All right.
Whoa, whoa.
Yeah, maybe.
Is Christopher Allen in custody? Are you Christopher Allen? Who is your attorney? Reagan Manali?
She's here this morning, Judge.
She'll be here. She's in and out. She's probably talking with some other people. Stand by. Christopher Broughton.
That's not the power of attorney.
Are you Christopher Broughton?
Yep.
Say it again.
He had already said it in power of attorney.
Xavier Curtis, where are you? Xavier Curtis. Xavier Curtis in 25 CR 284, no answer in the courtroom. I asked the bailiff to call into the hall for Xavier Curtis, please. What's the bond on the house?
There's no response, sir.
No response to the name being called here in the courtroom. No response to that name being called into the hall. The defendant has failed to appear.
Bond $15,000.
$15,000 bond. It is revoked and it is doubled to $30,000 bond. And a warrant is issued for his arrest. Also, he must have a GPS device as a condition of bond. Jasmine Delahousse. Come on in. Here's this. Yes. Christopher Allen is here.
Yes, Judge, he's going on his affidavit of admission to the full.
Please, you're Jasmine Delahousse.
Yes, sir.
Okay, you were charged with, as you probably know, the second-degree felony and burglary of a habitation, which carries with it up to 20 years in prison. So that's serious. Ms. Nowdy is your attorney. What are we going to do?
Judge, I need a 4-week reset to obtain media associated with her case and give her time to.
I don't even know why we have the initial appearances, because we're really, you need time. You need time. You know.
The first contact,
I guess it's just to make sure that they're around.
they requalify, Judge. That's the other.
We refill out the.
And sometimes they hire attorneys.
And sometimes they have.
Sometimes. So 4 weeks?
Yes, sir.
All right. Please get a resetting. Thank you. From that lady right here. Kennedy Polidor. Kennedy Polidor, please.
Okay, thank you.
25 CR 783. Mr. Polidor.
Correct. For you to sign on the next, right?
Mr. Polidor? Yes, sir. Okay. You were charged with state jail felony of evading arrest or detention. You have, though, 2 prior convictions out of this court back to 24 years ago for controlled substances, state jail felonies, 2 other state jail felonies. That brings that up, I believe, to a state jail felony punished as though it were a 3rd-degree felony. Everybody's looking at me like, I can't believe it's not better.
I'm not sure it's state of felony studies. So
it makes it 13.
Yes.
Is that your final answer? I think that's, you did this yesterday. Yes, sir. And that's what we figured out yesterday. Same thing. So it's punished as a 3rd-degree felony because of your prior convictions, which is the equation in criminal law. The crime, the circumstances of the crime you're charged with, and criminal history work together in determining what a sentence is. So that means you're looking at up to 10 years in prison. Okay. What are we going to do?
What I need to do is to obtain his media. Exact time to go.
Anything else we need to bring up here? You're on. On this, get a resetting for cool. It's easy. Devin Westbrook. Devin Westbrook, please come on.
You have to fill out everything, even if this is.
How old are you?
You have to mark it.
How old are you, sir?
I'm 17.
17. You're looking at life imprisonment right now. You know that?
It's not as well. I'm sorry. Everything has to be, you'll have to go and check on that.
All right. So that sinks in. You understand everything is serious in this room. Some are more serious than others. What are we going to do today?
Shocking. You still not work on the information on the document is true and correct. The highlighted, that's my third one.
Doesn't say anybody not. He turned 17 a month before he's alleged to have committed this offense. Well, that's aware that we have some money.
Yep.
You just turned 17. You're treated as an adult when you turn 17 in Texas. I mean, you didn't make it long as an adult, 17, before you've gotten yourself into a lot of trouble. And life in prison means at least 30 years of your life, 30 at least. And something, I guess, where a firearm is used, according to this indictment, you can't get parole until you serve at least one half of a sentence. Were you ever in any trouble before this? So do you? A lot? No, but okay, but what happened? You know, what? You knew mistakes have consequences. Did you learn from those mistakes? Okay, well, maybe this is fixable. You're presumed innocent. That's the important thing. But the grand jury has indicted you, which means they have probable cause. I'm playing the scales of justice. Probable cause to believe that you committed this crime. And jurors in this county are pretty serious when it comes to violent crimes, no matter what age. The wise thing to do is follow the rules and not get involved in behavior that could result in a crime. But here you are. Now, what are you going to do to try to fix this? Work with her. Yes. Your attorney, Ms. Manon. Okay. This is, you're going to want at least 4 weeks.
Yes, Judge.
Okay. I'm going to reset this to 4 weeks. With your parents? Okay. Anything else?
No.
In this? Okay. Does he have his paperwork done before? Go right there. Christopher Allen?
This is. Okay, everything has been developed, even if it's a zero, you have to write zero, okay?
You're on this one.
Yes.
Come on now. You are Christopher Lee Allen. Okay. In 25 CR 429, you are charged with the third-degree felony of unlawful possession of a firearm by being a convicted felon. But it doesn't stop there. It says that you were convicted out of Harris County in 2023 for unauthorized use of a motor vehicle. And Washington. Then thereafter, on February 2nd of this year, it's alleged that you committed this offense of unlawful possession of a firearm, which is a third-degree felony, carries with it up to 10 years in prison. But paragraphs 2, 3, and 4 allege that you were convicted for 3 offenses in this court in 2019, aggravated assaults, 3 aggravated assaults. And so if that's proven true and you're convicted of this offense in paragraph 1, this unlawful possession of a firearm by a felon, punishment range bumps up to a second-degree felony punishment range. So you're really looking, if this is true, up to 20 years in prison. And serious. So we got to treat it seriously. The best thing to do is avoid committing crimes. This is initial.
Yes. I'm still waiting on this media. I need 4 weeks.
Bet you need 4 weeks.
I do. Be safe bet.
Do you still live in Morgan City? Sir. Okay. Well, where are you? Because we gotta keep up with you. Your address.
My new address will be 3444 25th Street.
3444.
25th Street, Parker, Texas. 77642.
Who do you live with there?
My father's.
Your dad? Okay. And you also need to know under the law, because you have previously been convicted of a felony offense, you are ineligible for probation in front of a jury in Texas. You understand? That's foreclosed. So you're looking at straight time unless a deal was struck. The only courts, the judges can grant a form of probation under your circumstance, which is why it's a good idea not to get in trouble. All right, get a resetting.
Yes, sir.
And you wish to waive that hearing and admit to this violation?
Yes, sir.
All right, the court's going to find that you have violated the terms of your community control. Mr. Sexton, I don't know what to tell you. I mean, you put yourself in a very bad situation here. I mean, for, absconding from supervision is never an answer.
Right.
But this reporting requirement that you have to follow is going to just continue to follow you until for as long as you have to do it.
Right.
So, I mean, you still have things going on over in Butler County?
Yeah, I got to go do a CTP program.
All right. Well, I tried that with you before, and I'm not going to do it again. So at this time, I'm going to order you to serve an additional 60 days in the Warren County Jail. At the end of that, I'm going to terminate you from supervision.
Okay.
All right. So you
Thank
got
you.
60 more days to do. You have a 242 days jail time credit on this offense right now, but you're going to do an additional 60 days, and then I'm going to turn you loose. And if you don't register again, the next time you come back, you understand it's going to be a mandatory prison sentence.
Absolutely. Do I get time service for the time I've been here?
You got 60 more days to do, and then after
60 more counting now?
Yeah, 60 more. I mean, you have 18 months on the shelf. I'm not going to do that, but I'm not going to send you to prison, but you're going to do 60 more days in our jail. Okay?
All right, thank you.
All right, that's all. Your Honor, do you want to be a neutral? Just a neutral. Rhodes, where you been?
Hiding. Justin showed me all the good spots to hide.
Hearing. Mr. Kidd, does your client wish to have a contested hearing in this matter?
I have talked to Mr. Hasty both here and in jail. It's my understanding that he is willing to admit to one of the rule violations, that being that he failed to comply with the rules of sober link as ordered by defendant supervising officer. When talking more with her, that dealt with him not blowing within the time frame that he was supposed to be blowing in.
Mr. Hasty, do you understand the right you're giving up by admitting to this violation?
Yes, sir.
Is this what you want to do?
Yes, sir.
Do you admit or do you deny that you violated the terms of your supervision?
I admit.
Based upon that admission, I find you have violated the terms of community control. We have 392 days of local jail time credit, 120 days of prison time credit for a total of 514 days. Mr. Harris, anything from the state?
Your Honor, the state feels the defendant has been given every opportunity to comply with the rules, even was released on judicial at one time, has continued to fail to comply. We do not believe he's amenable to community control anymore and would ask that he serve out the remainder of his time.
Officer Martinez, what's the recommendation of probation?
At this point, Jeremy Hasty has been given specialized attention for his mental health, his dual diagnosis. He's been given every opportunity to be successful. Unfortunately, he has not been able to comply with the rules of his supervision. And so at this point, the recommendation of probation is that he serve time in prison.
Mr. Kidd?
Your Honor, on behalf of Mr. Hasty, he very much appreciated the opportunity of judicial release. He obviously acknowledged that in some ways he did not do everything he was supposed to do. Your Honor, he would still request an opportunity to remain on community control. I know that the coach has reached out, or he has reached out to the coach. They feel that there's a potential way, a potential avenue forward where they can assist him with his dual diagnosis treatment as well. He does understand what the court is intending to do or plans on doing, but he would again ask the court to reconsider that and allow him to remain on community control. He would comply fully with all mental health instructions in regard to that, and he would comply with all other conditions of probation.
What do you want to tell me, Mr. Hasty, if anything?
Your Honor, I'd like to say, it was a rocky road. I know you gave me the chance to come back and prove myself. And, Your Honor, I completed the Monday. I got out. I was doing good. And, I had a slip up. And then my mom got real sick. And then here I ended up going from getting out and supposed to go into intensive or aftercare after the Monday. And then I did that. I was going to online rehab for mental health and my medicine. And then she wasn't okay with that. So then I went to crisis care. Then I didn't get a doctor's appointment fast enough. So then I did get a doctor's appointment. And then now that I messed up, she put me in she told me I needed to go to Leora and just be get cleared from the withdrawal from the solar what's that called when you become where they cleared me from being detox. So then I did that, and I ended up in this program that I didn't even know that I was supposed to go to. And then now here my mom got real sick, and I was trying to do everything I could, and then they wouldn't give me my mental health medicine. And then I just started my mental health medicine the day that she came and took me out of this rehab, that she told me that if I messed up, then she was going to take me into custody. But I didn't mess up because I was doing what I was supposed to. She took me out of it. And I just feel like prison is not, she told me to advocate for my mental health, and I'm here to advocate for that because that's not what I felt like I got. I feel like prison is not going to help me, and I got a sick mother at home and a brand newborn child that needs me, and that's not prison time is not going to change my mentality. I need mental health treatment to do that, I feel. And sorry for taking the time, and I sincerely mean that, and hope that you give me a chance to not only prove to myself but prove to the court that I did good for a year and I can be a member of society and not just a participant.
Here's the thing, Mr. Hasty. This incident was, first of all, your record is terrible. Second of all, we tried everything that we have in the toolbox. We don't have anything else left that we can try to figure out how to get a working sort of model on this. And while I get that part of this is mental health, part of this is within your control, and you are not doing the things that you are supposed to do. But sometimes, Mr. Hasty, it's not even about you. Sometimes I have to vindicate the system. And if you can't do the things that you're supposed to do, I have to send you back to prison. And I know that doesn't do anything for you. And I know that that puts you back at square one when you get out. But also that's an opportunity for you to get into a treatment program. These treatment programs will accept you. You don't have to have a court order to go to a treatment program. You can do that and get this back on track on your own without the imposition of the court sort of hanging over your head. I do find that you have violated the terms of your supervision, and I am going to return you to prison for the 23 months. I'm going to give you credit for the time that you have already done. I'll do a separate order on the jail time credit. You're also subject to the post-release control that we talked about back at the sentencing. It's my hope, Mr. Hasty, do your time, get out, behave yourself, do the things that you need to do.
Ask one more question.
Sure.
So with post-release control, what's that?
Post-release control means that the adult parole authority has the option to supervise you when you are released. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It is automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for that new felony. But that's not under my control. That's under the Department of Rehabilitation and Corrections.
So what is that, like TC, like transitional control or whatever?
Transitional control is a separate, sort of separate animal. I do not believe that on this charge you are eligible for a transitional control, but you might be. And if you are, you can take advantage of that. But I don't think that you're probably eligible, but you might be. But again, those things are all managed by the Department of Rehabilitation and Corrections. I don't have anything to do with that. You're going to get a case manager when you get to the pen. Talk to your case manager. They're going to know way more about this than either me or Mr. Kidd. Good luck to you.
One more question. I believe the phone in question actually was purchased by his sister who's in the courtroom today. Would the court permit that phone to be returned at this time?
We don't have any more evidentiary value for anything in this case, right, Mr. Harris?
No, yeah.
Okay, send me an entry.
Okay.
Put in there who's going to pick it up and what the law enforcement agency is that has it.
Just to add, I talked to our evidence supervisor.
Oh, do we have it?
Yes,
We do.
they have it.
We have it. Our evidence supervisor stated that we need a receipt with the same serial number on it to determine whether or not who we can release it to. So if it has her information on it, we can release it in that way. But we can't release it to anyone outside of Jeremy Hasty is what I mean.
All right, so I'm going to put down an order. You're going to send me an order that says release to, what's the name?
Kia, correct?
No.
Kia Hasty, correct?
Kia Hasty?
TIA.
TIA Hasty.
TEA.
Oh, TEA?
I'm going to put down an order that says that. They're probably going to comply with that.
So the court will take care of that order?
Yes.
Okay.
As between Ms. Hasty or Mr. Hasty, I don't care who the phone belongs to. As long as Mr. Hasty, you're okay with the phone being released to her, right?
Correct.
Okay, that covers our basis there.
You don't need that now.
Everything's about to get
He's going to order it. You just need to come
All right,
in.
that's all.
Thank you, Your Honor.
Are we ready to talk about Williams?
Yes, sir.
Okay,
We are.
all right.
Hey, Langston? I'm signing up. Jasmine, right now, Jasmine? Oh, Jasmine, TC. Oh, no, we do. And probably there was gonna be a police. Yeah, he was a no-show, and so was revoked. Yeah. Yeah. It was doubled.
Yes.
This is. I need it all.
Do you want?
Jasmine, that's. Yeah, give me.
Okay, here's first.
Okay, thanks. Okay. 25 CR 364 is called the State of Texas versus Jasmine Dudley. Dudley? Yes. Present with Mr. Adams, your attorney, the state's attorney, and judge on her case. Here you go. Yeah,
This is what free, that is.
May concern.
That's a math of in-stock. Counselor, psychologist.
Hold on.
Also,
Mr. Boyd, you need to be up here on this, please.
definitely.
You- Yeah, again. Grand Central Station.
Yes, sir. Always is.
Jefferson County, Texas.
Yep. And I have a copy of the same thing for the state as well. I did some of my way too.
He's giving us papers. Homework assignment.
Homework assignment. No, just on the, what happened was,
Okay, what is this? This sounds great. What does this have to do with guilt or innocence?
what I did was I filed a motion to have her tested based on her side. It's my position that on the date of this offense, she was totally not in her right mind, and she's been under psychological treatment and she's had mental disorders. I end up getting the medical records, and that's why I gave you a copy of that, and I have medical records too if you want to go through them. I just wanted her to get tested by Mr. Perform, Dr. Perform, I should say. Because I don't think she had a clue of what was going on that day.
Well, you don't know.
That's what I think. I don't think this. That's what
Has she ever been diagnosed as being incompetent? Or
she's saying yes. I don't know. But he's saying
who tested you and deemed you to be incompetent?
Yeah, this operation.
When?
2016.
For why were you there? Were you charged with a crime?
No.
Well, that's what we check for competency. Or they wouldn't be checking for competency unless you were charged with a crime, man. So then you didn't understand. But you were in Baptist hospitals?
Yes.
Have you gotten those? Records? That would be so?
I believe it. Yes, sir. I just put those last night.
Well,
and that's what they were.
Yeah.
You should also have worked with AC. Yes. Not this will be on the hospital outside. Yeah. I did finish travel at the judge office recently for the test. Judge, this is a cycle. You can't tell the same one of the back to the This is bad. That's actually very bad for you.
This thing got, did you see how it got printed? Got printed, vertically, not horizontal. Weird. Well, there's a lot of edges.
Yes. Hitting that stuff.
I can show you, she reports her grandmother inconsistent Lexapro intake due to running out of medication, then using her grandmother's medication and to compensate. That's what you said. So don't act like, I can't believe it's not butter. I mean, that's what you told the people at the hospital. Which is. No, maybe with the powder and shit. So what you said to them. Well, they didn't make it. They don't make that stuff up. They just relate directly what you tell them. The thing what she appeared when she spit on the lady, she appeared intoxicated. They say, according to this. Question is, what happened when she was arrested? That they still send her to the hospital for a blood test or something? That would be important for all of us to know.
Yes. And on the date of this offense, Judge, she had prison a mid-cell. And that's the situation. If you need it, I mean, I got it.
Did you have copies?
I got copies. Oh, you can use it. You have it. But I know that, and this is what I was going to show you real quick.
Would you do something? I'm going to send, we're going to get her to Dr. Gopal. Can you follow that up with something in writing?
Yeah, I did. I filed the motion. I already did. Here's my copies of it. And I filed it already. I got extra copies. Yes, sir.
Okay, it's not in here.
I filed it.
Okay, but we'll do it.
Yeah. That was it right there. I filed it. That's my receipt showing I filed it.
Okay. Did you have a copy of it?
No.
Okay. All right.
But I filed it.
All right. We'll look for it. If we can't find it, we'll get back with you, but we will get her to Dr. Gopal for an evaluation on this too.
Thank you, Judge.
Okay. Reset 6 weeks. Okay.
That's perfect.
Okay.
He does it on.
Next is Kara.
That's a plea. I'm doing the paperwork now. You want me to
finish it? Yeah.
Okay.
On the holiday.
We have 3 cases, right?
Yes, they all gonna be disposed of today.
Good working.
Let me get this.
Okay, thank you. Adam Dixon. Thomas.
I need to talk to the prosecutor. I think it's set there.
This is a plea hearing.
To write something up.
Melvin Espinal, Mr. Crenshaw.
Your Honor, that's a plea. If we could come back in 30 days, it'd be a plea for time.
Where is Mr. Espinal?
He's right there, and that's who Judge.
Okay, you're doing something else?
No, I'm working on another client.
Okay, so why don't we take care of this one and move him on?
Yes.
Okay, come on up.
Come on up, no. It's okay. We're working. We're going to. Well dressed, I client, but what's my Judge?
Really long.
with the prosecution. I won't give us any consideration.
You know what? I'm in,
Control substances.
Mr. Espinal is down. I don't have that. Here.
It's right here.
23 CR 440 is now called. You are Melvin Espinal with Mr. Crenshaw, your attorney. You're charged, of course, with third-degree felony of operating a motor vehicle in a public place while intoxicated.
And Judge, we have a resolution for 3 years TDC, and we could just reset it and actually and get his affairs in order. We get ready to do this. He's had an analog device now for almost 3 years. He hasn't had any problems.
He has one.
Hasn't had any problems with the analog device for 3 years.
His hands behind his back after he was informed that he was being placed under arrest. The defendant resisted orders. General condition number 7, on August 5th, 2025, the defendant tested positive for methamphetamines.
Mr. Heaton, you have the right to be represented by a lawyer in this case. If you can't afford one, I will appoint one for you. You want to be represented by a lawyer, right? Why not?
I just want to be sentenced and get it over with.
What does be sentenced and get it over with mean in your world?
Whatever you're going to do to me, I'm going to accept it and go on with it.
All right. Ms. Carrillo has a waiver that tells me in writing that you don't want to be represented by an attorney. I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated probation?
I admit it.
Based upon your admission, I find you have violated the terms of your supervision. Mr. Harris, anything from the state?
Your Honor, we'll defer to the recommendations of probation.
Officer Martinez, what's the position of probation in this?
Kenneth Heaton has a long history of mental health. It was just uncovered that there's also some significant drug use involved in this case. Due to the continued use of methamphetamines, his aggressive behavior, the fact that our officers had to go hands-on to arrest him, and the fact that his criminal history shows that he's threatening and he harms people out in the community when he's not mentally well. I am still advocating that he gets help, but because he is not willing to work with us at this point, the recommendation is that he be revoked from probation. I would encourage Kenneth to get the help that he needs because probation genuinely cares for him and wants him to be successful.
What do you want to tell me, Mr. Heaton?
I don't really know what to say.
Sometimes there's not a lot to say, Mr. Heaton. I mean, I get that. It just seems like when you are not on your medications and if you're not operating at a very high level in your consciousness, you're very dangerous to everybody around you. That's unfortunate, but that's just a reality that we have to deal with. I find that you are not amenable to community control. I am going to sentence you to 12 months in prison. This includes an optional period of post-release control. That means the adult parole authority can, but is not required to supervise you for up to 2 years after release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. I'm going to give you credit for the 97 days that you have already done. When you get to prison, Mr. Heaton, you might be eligible for transitional control, early release. If you want to sign on for any of those programs, that might be a good resolution to this, but you're eligible for judicial release technically, but I'm not going to give you judicial release.
All right.
Just finish your time out and be done.
Thank you, Your Honor.
Good luck to you, Mr. Heaton. Next is the case of the state of Ohio versus David Banks. This is case numbers 21 CR 38825 and 22 CR 40000. Present before the court is Mr. Banks, right?
Yes, sir.
And we have Mr. Harris in the prosecutor's office, Officer Sukovecki from probation. We're here today, Mr. Banks, because I have received a report that alleges you have violated the terms of your supervision. Officer Sukovecki, what are the allegations?
General conditions rule number 7 on July 28th, 2025, the defendant admitted to his probation officer that he used methamphetamine on July 26th, 2025.
Mr. Banks, I'm going to be setting this case for a final hearing. That's going to take place in about a week to 10 days. You have the right to be represented by a lawyer at that hearing. Do you want to be represented by an attorney?
Yes, sir. Yes, sir.
Are you going to hire an attorney or do you want one appointed?
I don't have the money, sir.
I think I'd previously appointed Mr. Brenner to represent you.
No, sir. I don't want him.
You don't want Mr. Brenner?
Sir.
All right. Who else do we have? I'm sorry? Oh, Ms. Hinkle. Okay. So I'm going to appoint Ms. Hinkle to represent you. You have an affidavit that tells me that you don't have the funds to hire a lawyer. All right, I do find that you're indigent for the purposes of hiring a lawyer in the case. We're going to set it for a final hearing. Is there anything you want to tell me today?
Your Honor, I apologize. That's the only thing I can really do, Your Honor. I had everything going, man. I just got back, my son back in my life. Just doing the custody battle, or not the custody battle, but visitation. Only really thing I can do, Your Honor, is just apologize for what I did. I just lost my footing. Honestly, God, I had everything going, and Hillary Evans has been a blessing. Like, all I can do is apologize, Your Honor.
Yeah, so here's the thing, Mr. Banks. There is a dust up on the horizon about what should happen in this case. And I know that Officer Evans feels strongly that I should continue you on supervision. I also feel strongly that you need to accept the responsibility and the punishment aspect that goes along with this violation. So we are going to have a bit of a dispute about what should happen with you. We'll see what happens at that, assuming that you violated the terms of your supervision, about what we should do next. I really don't know what I'm going to do as I sit here, because I know that Officer Evans is going to try to convince me to put you back on probation. I don't know if I can do that or not. But I'll see you in about a week to 10 days. We're not going to make that decision today. You need to talk to Ms. Hinkle so that you can present your side of it. Also, I want to hear from Officer Evans. Okay. All right. Next is the case of Justin Rader. This is case number 23 CR 40494. Present before the court is Mr. Rader, right?
Sir.
We have Mr. Harris from the prosecutor's office, Officer Sukovecki from probation. We are here today, Mr. Rader, because I have received a report that alleges that you have violated the terms of your supervision. What is the allegation?
General conditions rule number 7 on May 28th, 2025, the defendant submitted to a drug test which tested positive for methamphetamine and amphetamine. On June 12th, 2025, the defendant submitted to a drug test which tested positive for methamphetamine and amphetamine. And on July 22nd, 2025, the defendant tested positive with a new behavioral health 2, which the lab confirmed positive for methamphetamine and amphetamine, and the defendant later admitted to use.
Mr. Rader, you have the right to be represented by a lawyer in this proceeding. If you can't afford one, I will appoint a lawyer for you. Are you going to be represented by a lawyer in this case?
I would like to just plead guilty today, Your Honor.
Okay. Regardless of whether or not you admit or deny this violation, I'm going to set this for a final hearing, which is going to take place in a week to 10 days, because Mr. Harris is going to want to get the victims present for the hearing as to final disposition. So we're going to be having another hearing. If you want to be represented by a lawyer at that hearing, I can make that happen. If you want one appointed, or if you want to hire one, that part doesn't matter to me.
I'll do it. I'll take a lawyer, I guess.
All right. Ms. Kuroko has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. I do find that you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Ms. Chambers to represent you. You have her contact information there. We're also going to send her an email today that lets her know that she's been appointed. I'm going to set this for a final hearing in a week or so. Anything you want to tell me today?
I just want to apologize for my actions, Your Honor.
All right, I do find there's probable cause to believe you have violated the terms of your supervision. I'll see you in a week or so. We'll figure out what to do about all this. All right.
Thank you.
Next is the case of the State of Ohio versus Scott. This is case number 24 CR 41610. Present before the court is Mr. Forrest, right?
Yes, sir.
We have Mr. Harris from the prosecutor's office, Officer Sukovecki from probation. We're here today, Mr. Forrest, because I've received a report that alleges you have violated the terms of your supervision. Officer Sukovecki, what is the allegation?
General rule conditions number 7 on July 14th, 18th, and 21st, the defendant submitted to urine screens with River Rocks Recovery, which were positive for cocaine and marijuana.
Mr. Forrest, you have the right to be represented by a lawyer in this case, and if you can't afford a lawyer, I will appoint one for you. Do you want to be represented by a lawyer? Do you want me to appoint a lawyer for you? All right, Ms. Carrillo has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. All right, I do find that you're indigent for the purposes of hiring a lawyer in the case. I'm going to appoint Ms. Kirby to represent you. You have her contact information there. We're also going to send her an email today that lets her know that she has been appointed. And we're going to set this for a final hearing probably in a week to 10 days. Is there anything that you would like to tell me today? All right, I do find there's probable cause to believe you have violated the terms of your supervision. I'm going to hold you in jail until the final. I'll see you in about a week. Case of the State of Ohio versus Terry Johnson, case number 24 CR 41798. Present before the court is Mr. Johnson, right? We have Mr. Harris from the prosecutor's office, and we have Officer Sukovecki from probation. We are here today, Mr. Johnson, because I've received a report that alleges you have violated the terms of your supervision. Officer Sukovecki, what are the allegations?
Special conditions 15H on July 28th, 2025, the defendant for probation that he was refusing to participate in the CBCF as ordered by the court.
So we explored some options and then you changed your mind, right, Mr. Johnson? Tell me what's going on with this.
I wrote you a letter. I don't know if you got it or not.
I did.
I'd rather just do my whatever time that you're going to give me so I can be off probation and be a free man.
Okay. Well, first of all, the reason this has to come back to me is because we resolved the old violation and we had a plan, and then you're not going to go to the STAR program. So I assume that you don't dispute these allegations. Do you want me to appoint a lawyer? What's your thought on this?
I'm just trying to be done with it. If we can handle it today, then we can.
Okay. Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by a lawyer. Do you admit or deny that you violated the terms of your probation?
Admit.
Based upon your admission, I find you have violated the terms of supervision. Mr. Harris, anything from the state?
Your Honor, I think it's evident the defendant is not amenable to community control or the recommendations of the court or probation. We would see prison as the only option at this point.
Mr. Johnson, what do you want to tell me?
Nothing really except what I put in the letter. I just want to do my time and get back free so I can do what I have to do. I don't really get in trouble for real. Y'all will never see me again or any other county. I'll never see prison again either.
What's our jail days, Officer Sukovecki?
56 days, Your Honor.
Does that sound right to you, Mr. Johnson? 56 days as of today?
add it together from what you said last
I mean,
week.
from everything to today, it's 56 days, right? Does that sound right?
Okay, I don't know, son, honestly. I don't know, honestly.
Okay. Because I mean, last time we were here on July the 24th, you had 43, so that seems about right. All right. I mean, Mr. Johnson, it's not a prison case. I'm not going to send you to prison, but I do think that you just need to serve out some time. So I am going to order that you serve 150 days in the county jail. I'm going to credit you with the 56 days that you have already done. I'm going to make you eligible for the litter pickup program. So if you want to go out on the litter pickup crew, you will get an additional day of jail time credit for every day that you go out on the crew. Technically, you're on probation during the time that you're in the jail, community control. So if you violate the terms of the jail, get caught with drugs, get in a fight, I could still send you to prison for up to the maximum penalty in the case, which is 6 months in jail, or I'm sorry, 12 months in jail, prison. But finish your time out, be done with us, get on with your life.
Thank you for giving me that option.
All right, good luck to you, Mr. Johnson. Next is the case of the state of Ohio versus Chad Creech, 23 CR 41302 and 23 CR 41207. Present before the court is Mr. Creech. We have Mr. Harris in the prosecutor's office, Officer Sukovecki from probation. We're here today for an early termination hearing. Mr. Harris, anything on behalf of the state?
Your Honor, the victim was attempted to be contacted. I think they did get a hold of the husband of the victim. They did not have any further input. We would defer to the recommendations of probation.
Anything additional from probation, Officer Sukovecki?
Nothing further, Your Honor.
Anything you want to tell me, Mr. Creech?
Yes, Judge. I've just made a turn in my life. I've actually got a fiance now. I'm getting married next month. Trying to just get off probation so I can move forward with my life. My business is doing well. She's from Vietnam, so we're wanting to go over to her country. And I just obviously haven't completed all the requirements that you guys have asked me to do, passed all my drug screens, paid all the restitution. I'm just asking that I can be released.
Mr. Creech, if DraftKings were allowed to place money on whether or not somebody would successfully complete intervention in lieu of conviction, I can assure you that there would have been a lot of wagering that you would not have. But you did everything that we asked you to do in this case, and there's no point in continuing to supervise you, so I am going to grant the early termination. Good luck to you.
Thanks, Your Honor.
All right.
For his alcohol issues.
Yeah, what about that? Because this is your sixth DWI as a felony, right?
Yeah.
Yeah, which meant you must have had two before that. 8.
No.
This is
He's has 5.
5 felony convictions.
No, you're not.
This is 2. These are all.
That's not.
That's not. Oh, here's county criminal courts in Harris County in 09.
So this is number 5.
But still, 5's too many, right?
Understood.
What are you doing to fix this?
He's on a prescription. What's that prescription called?
Trexon?
Next Trexon.
Put their taking these. They'll put the restitution responsibility. During 30 days later.
He's got a great job. He's got a new wife.
Got things to lose here by making mistakes,
We
right?
try to get probation judge with the state wants to do 10 time, which we understand considering the facts and circumstances.
Yeah, these are this little farm right here. You gotta remember, the DWI is kind of a selfish thing because we're out there with everybody else driving these 4,000-pound missiles around town. They can do a lot of damage when they run into each other. That's why you have to operate those things responsibly.
Just feel with that decision, it's just.
Are you going to fix this?
Absolutely, yes, sir.
When it's not
I think 30, 45 days, she was going to get us
6 weeks, go ahead. Okay.
Thank you, Judge.
Yeah. Jerry Hanley.
Yes, that's a plea, Judge. We're doing the paperwork right now.
Okay.
And then the last file.
Jerry Hanley. I've got Jerry Hanley on 2 cases.
Oh, 2 cases, yes, Judge. That's be a resolution. Cody Hatch is right here. Come on, Cody. Judge, that's not a resolution today. I'm optimistic this will
Mr.
be
Hatch.
a dismissal or production. This was Mr. Eckmar case, and Mike just needs some time to do a little research and come to his senses. Thank you.
Have you ever known me to come to my senses, Judge? You say a little time?
Just a little time.
You're almost 11 years, I don't think I've come to my senses. You're Mr. Hatch?
Yes, sir.
As you know, here you're charged in 23 CR 1093 with 3rd-degree felony of operating a motor vehicle in a public place while intoxicated. So you're looking at up to 10 years in prison. So this is serious, and it should be. You heard what I said. The one to the person before you. Are you still here in Port Neches?
Yes, sir.
I pretty much grew up with my cousins on Merriman in Port Neches. I grew up in Groves, but my cousins who were my age were on Merriman Street. And it's interesting. There's a Marion and a Merriman.
Yeah. Well, that can be confusing.
It can be. I'm wondering how much was going in different places because of that. Wait, how much time?
Judge, if we could just do a standard reset on this one.
There's nothing standard in this room.
Yes.
Yeah, 5 weeks.
6.
6, good. Yeah, couldn't settle out of court there on that one. 6 weeks. You got to reset or something.
Good to see you. Thank you. Yes, sir.
Waylon Levens is another one.
That was reset.
It's not. Well, it is.
Washington. Washington.
Hey, so you got, there's Waylon Levens on this, Matthew Sharp,
Those
America.
are all my cases that weren't more than
Justin
10 days old. Reset, Judge.
Okay, they showed up on this one. All of these are off the chart, right?
Correct.
Waylon Levens, okay, that's
all my cases except
Sharp,
share with Mr. Burns.
Van Meter, and you Walker.
Yes.
Okay. Yesenia Alvarez.
That's mine, Judge. We just need some additional time. That's neither do I have sheet presence.
Alvarez.
6 weeks, please.
Raise the right hand and swear upon Christ and your soul truth and I'm sure yourself be God. You got to know right something. Place it flat on the wall. But one more time, I need a little bit darker. Okay, right here. Have a seat for before you even move.
Yesenia Alvarez. They'll need to, like the rest of these, for around down and just do this style. Yesenia Alvarez, Yesenia, yeah.
Yes.
All of those, a bunch of those need, okay. Hatch, Cody Hatch, William Levens, Matthew Sharp, Van Meter, and Walker all have been reset. Okay. So we don't need that.
Yeah.
I need whatever's after this one.
You want the whole stack?
Yes. Okay, you're just getting started. Oh, in this one, what am I doing? Oh. 25 CR 348, you were charged with the state jail felony of operating a motor vehicle in a public place with a child while intoxicated. So you're looking at a state jail felony, which carries with it up to 2 years in the state jail. So it's serious. And today we're going to do what?
We're just asking for additional time.
How much?
Maybe 6 weeks, Judge.
6.
Yes, please.
Did you already go on your trip? Are you going? Okay. Next one. What do we say? Be careful driving, man. You know what I mean? You know what I mean? Okay, Lou.
Judge, I'm working out paperwork for so we're dealing with it right now.
Oh, hold on, Kevin Romero.
Judge, yeah, he's present. Come on up. Mr. Crenshaw and I are on that.
Oh, we're our best men on the job. So remember that commercial? Yeah, I got my best men working on it, and they're all laying on the car.
Yeah.
Sleeping. Yeah. How's my car? Repair. Oh, I got 2 of my best men on it. And then the camera shows they're sleeping on the hood. Yeah, go ahead. That's not applicable.
Not what we're doing here.
I just remember that as a funny commercial.
Judge, we're waiting on some medical records. This is a case
Okay, you need some additional time, and your name again is Ramirez?
Yes, sir.
This is Mr. Ramirez?
Yes. Probably 8 weeks on this because it's just taking a little long to get the records.
All right, 2 months.
Have you graduated yet? Yes, sir. Okay.
I was going to ask you that, Corey.
Has he graduated?
Yes.
No, not yet, Judge.
What's your joke about graduating similar to law or something? Don't you have don't you have a corny joke about that?
Yes.
Yes, he does.
Yeah,
Please tell us.
My family all graduated magna cum laude. I graduated laude. How come? It was a different kind of an award. It was a different kind of award. Yeah, we have. Yes, come on up. Carol. Carol Quibido.
We said.
Langston, was you just pleading to one case?
Just one case.
Which one is to be dismissed?
So 2 state jail felonies. She's pleading to second degree murder without patient.
Okay. Yes, I need those 3. Again, thank you.
All right, split it up.
You'll find some jail. I'll bring mine. How's that sound? You call 24 CR 1317, and 1318 and 1319. And the state of Texas versus Clara and Equibido. That is you, President. Mr. Adams, you're returning to the state's attorney. In 1317, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in a summary fashion?
Yes, sir.
In summary, this indictment alleges that on or about April 14th, 2024 in Jefferson County, Texas, you committed a second-degree felony of burglary of a habitation. Do you understand what you are charged with? Yes. If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. You understand the punishment range applicable for this offense.
Yes.
An agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended, and then you would be placed on regular probation, which can be up to 10 years in length. A fine will be assessed at $500, plus you must pay restitution in the amount of $1,338.16, which I presume will go to the complainant in this case. That's correct. The owner, Karen Rourke, who's mentioned in this indictment. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this charge? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I'm going to show you what's marked as State's Exhibit 1. Did you sign that document up at the top?
Yes, ma'am.
Did you understand it, discuss it with your attorney, Mr. Adams, everything true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it is admitted. Among other things, thank you so much. This states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. That's you've read it. You will give the crime charges and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by the lawyer. All true, so help you God. State's Exhibit 1. Pre-sentence report is waived.
Yes, sir.
Then I will so find you are pleading guilty. Voluntarily knowingly and intelligently. There is sufficient evidence supporting the guilty plea. The State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You're giving up your rights to free trial, your rights to the appearance, confrontation, and cross-examination of witnesses. You're totally satisfied with your representation, and I am going to follow this agreement. You were hereby found guilty beyond a reasonable doubt of this second-degree felony of burglary of a habitation. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That will be suspended. You will be placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be fined $500. But even more importantly, there is restitution, which will be owed in the amount of $1,338.16, which needs to be paid back to the complainant in this case. How long will it take you to get that money back?
Maybe a couple months.
I'm going to give you 3 months, okay? Almost took it as a souvenir. 90 days, okay? And that will be part of the probation order. Restitution to be paid within 90 days. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Fix this and move on with your life. Do better. Okay. What were you going to say? What were you going to say?
See, Tom, I don't know who I owe money to.
They're going to tell you. It's in the name is in the indictment, and the probation office will work you through all of that. Okay. Yes, ma'am. Anything else? That is all.
Thank you, Judge.
Yes, sir. And two other cases, 1318 and 1319 on Kara Quibido are being dismissed at this time. As part of this agreement.
You're going to hear.
Who do you have? Corey, your patient.
I have Mr. Hanley, Judge. Already sent the paperwork to the state. If you can just give it to
He needs to come in front of her.
Okay. Here. Perfect.
Is it done?
Dismissal. He had my phone swim shit, so a lot of
Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, and if so be God? Then with right instruments. Let's get that as in. Get that more up. And make sure no one's ready. Go stand in front of judge.
You know, these pads, I know they're new, but there's so many things going wrong with them. So many things going wrong with them. And this one now is locked. I think it's unlocked.
It's not locked to Judge, and there's also a lag today.
Oh, here, I have a criminal law.
Well, you can't even, if you, like, the way I write left-handers, you know,
It lags.
well, then you do it and then it marks all over the,
Okay, try, I'll try to explain the law.
no, I'm okay. How do you explain that to the nut?
Good luck.
I got hit with a stylus right between the eyes.
But when I was falls up just blood.
Yeah. Thanks.
Thank you.
I know it's progress, but it is the writing. You can't write.
Oh, it's horrible. My penmanship is already rough. I've had that.
We're getting new ones October first,
Oh, great.
the new budget.
I thought these were. I thought these were.
That's not a day before.
Okay, next,
This is Mr. Hanlon.
Mr. Hanlon.
He has two cases, Judge. He has a theft that's being dismissed in exchange for restitution in full, and another state jail felony we're proceeding on the lesser of attempted.
Do I have that or just do you have hands?
Yep, you get that.
Which one? To be pleaded?
We were pleading on the prostitution case, Judge.
229. Okay, 25 CR 229 and 23 CR 1459 are both called the state of Texas versus Jerry Stephen Hadley, which is you, sir. And you were present with Mr. Crenshaw, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here in 229? Can we proceed in summary?
We can, Your Honor.
In summary, the indictment alleges that on or about November 21st, 2024 in Jefferson County, Texas, you committed the state jail felony of solicitation of prostitution. I'm looking at the plea agreement here, and it's been written all over that you would be pleading guilty to the lesser Class A misdemeanor of attempted solicitation of prostitution, which carries with it up to 1 year in the county jail and or a fine up to $4,000.
Judge, there's restitution from the other case that's included in to give him 30 days to pay as part of this plea bargain agreement to dismiss the other charge.
It's a large amount, Judge, but he's got the money. We just need to move it to the right account. He'll be paid.
Okay, is it going through this case?
Yes.
Yes, sir. It's going to go through this case.
Yes, sir.
So what is that?
30,371.03.
All right, then.
It's in the, I think it's in the plea agreement on the punishment part.
Okay. Let me ask you, you brought on this one, 1 year and or what's that?
$4,000 fine.
That's 4,000?
That's four. Yeah, that's a 4. That's 3 zeros, and we're fine.
In what language? I was just say.
Swahili.
Script?
Times New Roman.
Okay. What I need to do is use put the dollar sign so I like to do. There's two. There's no way to do it.
Did you put a fine on this?
I did not.
Okay, that's what I thought.
It's remained at 30,000.
Yeah, there's another case. I gave you that salt. On that, I stopped her to take that something. No. That's all. Jesus, that's just making sure. No.
I'm just kidding.
Making it worse.
Yeah, that's what it's judge.
Okay. Information about it, for some reason.
You didn't have to use that. I would do the finger phone. That's not different.
I left and he's getting got.
No, yeah, it's in judges you now.
I don't know why I'm.
We're all struggling.
Yeah, it's okay.
We give me public October.
So again, you're looking at up to 1 year in the county jail. And, or a fine, or up to, $4,000 fine. Do you understand?
Yes.
We don't have jail in there, it's up for 1 year. And we all know it is.
Okay.
She said, just have to see go.
You understand what you're going to be pleading to, the lesser included offense and the punishment range that's related to it, sir? The agreement's been reached where you would be placed on deferred or unadjudicated probation, which can be up to 2 years in length. And got some. There's no fine. And another case, 25 CR 1459 will be dismissed as part of this agreement. And you will also be ordered to pay restitution in the amount of $30,371. $30,371.03. That will go to whom?
Oh, go. What was your previous employer? Siddons Martin, Judge, SIDDONS Martin, Standards Appellate.
Is this part of the 1459 case?
Yes.
Okay, there is an owner there, McLeod. Is that the person?
No.
No.
But that was his boss.
That was the boss. So there's a company that owns.
Yes, that was his former employer.
Okay. What's the company's name?
Siddons Martin.
Okay, so restitution will go to Siddons Martin. And that's a company.
Yes.
How do they spell it? SIDDONS MARTIN. Yes. Okay, where are they located?
Port Arthur.
In Port Arthur, Texas. Houston's corporate office. Okay.
But you were at their Port Arthur office.
Okay. If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will.
Yes, sir.
And because you are guilty.
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. And you hadn't signed this. The bottom. Here, use this. This pen's a lot better. The stylus works better. So right there. I know you reviewed that document. It was discussed by Mr. Kinshaw. That's the way he does things. He takes care of his business. And have you discussed this with him? And is everything true and correct here on State's Exhibit 1?
Yes, sir.
State's Exhibit 1 is admitted into evidence without objection. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer, all through so help me God. States Exhibit 1 is part of the record for all purposes. Pre-sentence reports waived.
Yes, sir.
I'm going to follow this agreement and find that you are indeed mentally competent, sir, to enter this guilty plea is freely and voluntarily made. You know and appreciate the consequences of entering into this agreement. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am not going to do this. So long as you follow the terms and conditions of probation, I will not find you guilty. You will be on what we call deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation which are normal and customary for this type of offense. Most importantly here, restitution is agreed by all parties to be owed in the amount of $30,391.
71.
That's a 7? Okay. $30,371 and
3 cents.
3 cents.
that's it. Okay. Well, no,
Yes, sir.
Nobody's at fault with this thing. You can't. This doesn't look like a 3 and it doesn't look like a 7. And but you understand, I'm reading into the record, and we're going to have to fix this on this pad. That will be owed. How long is it going to? How will you make these payments here? Probation for 2 years.
He's going to be paid in a couple of weeks, Judge. He's already withdrawn the money out of his retirement. We're just going to move it between accounts.
In a couple of weeks?
Yes, sir.
So what I'm going to do is order this to be paid within 4 weeks. Is that going to be enough time?
The agreement said 30 days, Judge.
30 days. 30 days. That's a little more in 1 month. 30 days. Okay. As a condition of this agreement. Please see the probation officer.
Yeah. Order shot.
No, did I sign it?
No, I don't.
Thank you.
The other one was to search them.
And there's a dismissal, I think, coming, right?
Under civil law, it is.
Huh?
Under civil law, it is.
Please see the probation officer. Thank you.
Thank you, Judge.
Yes, sir.
Have a good day.
And you too. Thank you.
Yeah,
Okay, and we have a dismissal forthcoming, right? On 1459. On Mr. Hammond. Let me know when that.
I don't have the dismissal just yet, Judge.
Jakeisha Bernard. We ready on that? Who's your attorney? Who?
She has time.
They left?
No.
Sir, okay, we gotta wait for them to give them. Thank you.
I do need,
Naylik, Washington.
we can see in front of me.
Naylik, Washington. Malik.
We're ready, Your Honor.
This for not, this is not, and this short one.
He's already against the line as well.
Selfie back. We'll see. Stand up your right comfort. That's flat. Down long. You can hold your hand. All right.
Yeah, okay, there it is.
Okay.
25 CR 213 is called Naylik M. Washington. That's you?
Yes, sir.
Present with your attorney and the state's attorney. Mr. Padgett, does the defendant waive a formal reading of this indictment? And
He does.
arraignment, can we proceed in summary?
And we can, you know.
In summary, Mr. Washington, this indictment alleges that on or about October 16th, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of unlawful possession of a firearm by a felon being convicted previously of aggravated robbery in 2015 out of Hardin County, District 4. Do you understand what you were charged with?
Yes, sir.
Yes. This is a 3rd-degree felony if convicted, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. And there would be terms and conditions of probation, normal and customary for this type of crime. Do you understand that to be the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
How do you plead to this? Guilty or not guilty, sir?
Yes.
You have a soft voice. Are you pleading guilty voluntarily and because you are guilty?
Yes.
Okay, she has to take everything. I show you what's marked as State's Exhibit 1. Here, James.
Yes, Your Honor.
Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objections to State's 1, Your Honor.
Without objection, admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You might have read here. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for that purpose. Is pre-sentence report, Wiley?
Yes, Your Honor.
I'm going to follow this agreement then. I'm going to find that you, sir, are pleading guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of a firearm by a previous convicted felon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Justice to serve a term of 10 years. That will be suspended. You were placed on regular probation for 10 years. You will be fined $500. There will be terms and conditions of probation that the probation officer will go over with you here in a few minutes. Make sure you follow this. If you fail, your probation can be revoked.
But they can see that on person.
Yeah. Well, he's definitely afraid of me filling out anything.
Yes, well, I heard something about that, but I didn't want to speak.
That's the word on the street anyway. I think I saw that on the news.
I didn't see that.
Don't let him sign anything.
Never watched the news. I don't even have local TV stations. It's between. A little calmer.
All right, one other thing. Your second felony conviction. You know what it means next time? 25 to life. You're fixing all this, right? We're changing, we're going on the right path. Right, make better choices.
To be honest with you, he has a very good career and
a lot to learn. You've got a lot to live.
It's just the weapon situation. You got to be cash business.
I know, but you got it's like a minefield you got to deal with. But when you have that prior conviction, you have to be careful where you walk. You don't want to step on a mine. And this next one's a really big explosion. A third one. So you don't want that. Okay, but it's fixable. Please see the probation officer. Thank you.
Thank you.
Yes, sir. Ryan, y'all had something?
Yes, that's from
who is this?
Luke Cooper.
Luke Cooper.
Please deal.
Come on.
I know that's so rare for me to please something. Throw me off for a little bit.
I'll notate it on the calendar. You get a gold star.
Mike was being reasonable. It was reasonable Wednesday.
24 CR 1888 is Luke Anthony Cooper. Mr. Cooper. And you were here with your attorney, Mr. Dirks, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment can be received in summary?
He will, Judge, and we can.
In summary, this indictment alleges that on or about April 30th, 2024, in Jefferson County, Texas, you committed a third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with here?
Yes, sir.
Okay.
Yeah, I think everything now, just so you got the
Okay, we have a lesser included evading arrest, right? Which is a class A misdemeanor.
Yes, sir.
But y'all have, no, it's this.
The tablet, it's just having delay. That's
It's.
But I thoroughly.
I want to spoil that was. Just make sure you do it right.
Different range in this.
Oh,
Can't read by right.
we've never had that occur before, have we? No.
We haven't had that at all before.
It's it.
Talk about me.
No, it's Jane. It's not James.
He's a lefty, so the house, it was that. What are you doing? Move it.
No,
It's still stickly.
there's no problem.
I think it's the pressure. Oh, okay, it's a pressure.
Okay, class A misdemeanor carries with it, if convicted, up to 1 year in the county jail and or a fine up to $4,000. Do you understand?
I understand. Sir. Much. Yeah. Okay. There's something to try to go good. But yeah, it's the order of the trial. And I'm.
Let me do this. I'm gonna order this. We'll stay in it.
Yeah, Helen, Ryan, I wonder if you wore like a glove, like a golf glove, so when you do it. It's
This drives me crazy. There's been. I'm not thinking. I don't know why I'm right. It's not. You can go as fast. Forward. Yeah. Yes, I have seen this some more. Yes, yeah. I do. I was right. It looks like this. It's just. Every time you set your phone on, what's that? I'm intrigued. I design since it's just getting some of the freedom.
I got you how we smash that. I'll figure I'll figure that out. On Thursday in the morning. Yeah.
Now I got, you're already doing a lot on there. I work for a lot on my.
An agreement's been reached where you would be placed on deferred or unadjudicated probation for 2 years. There's no fine. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
That's wrong. What you're saying. Yeah.
If I follow this agreement, you have no right of appeal. Do you understand?
I understand, Your Honor.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of this offense and any lesser included offense? I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime and any lesser included offenses like this one that you are actually pleading guilty to. You are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is hereby granted.
Yes, Judge.
I am going to follow this agreement, sir, and find you are pleading guilty to this lesser included evading arrest or detention, a Class A misdemeanor. You are doing this voluntarily, knowingly, intelligently, mentally competent to do so. You understand and appreciate the consequences of pleading guilty, even though there's sufficient evidence to support a finding of guilt beyond a reasonable doubt. The court is going to defer and in finding of guilty, place you on deferred or unadjudicated probation for 2 years. Make the most of this. There will be terms and conditions of probation, which are normal and customary for this type of offense. And I think defensive driving is going to be one of those, which is really a win. It's a win for you because your insurance will be decreased. The cost of your insurance will be decreased by taking this as a requirement of probation. So yeah, you can't say that you're being stung on that one. You're getting a benefit here. But you understand the seriousness of this. I don't have to tell you. We have far too many terrible things that have happened with people fleeing the police, and then a crash happens, and then we've had weeping and crying fatalities, and everybody's sorry. But you can't, it's a mistake. Welcome to the world. You made a mistake. We all do. Everybody in this room has made it. Fix it. Okay. And that's the test of character. It's not the fact you make a mistake. It's how you deal with it. Deal with it responsibly. You'll be fine. Anything else? No. Please see the probation officer. Thank you. I had already done the plea on hand. I think there was a dismissal.
Yes, the dismissals over. Yeah.
Right. This is impossible. Security instructions on that. Somebody's buying this question. And it's just an area. Okay, 23-1459. Jerry Stephen Hanley, that case is dismissed as part of the plea agreement. Man, it's really slow. I have Jaquisha Bernard. And your attorney is?
It's Miss Minaldi. She was.
Miss Minaldi.
Sitting.
We have to wait for her to come back, man. Thank you. We already did Luke Cooper, right?
That's the one we just did.
No.
Leon Goodman.
Yes, Your Honor. Good morning, Your Honor.
Yes, sir.
Awesome.
Twenty-four CR 2385. You're Mr. Goodman?
Yes, sir.
You're Mr. Samuel, your attorney, and the state's attorney. What are we doing today?
Your Honor, this is the first setting. We'd like to have a reset, complete discovery, and further communicate with the prosecutor.
Let's go on. How fast? This is the sign one. This is the same. Have we done something with this?
No, I don't have any notes on file.
Here, he's tested positive for cocaine, bencyclidine.
This is mine.
Yeah, he had that. I don't remember getting this, but because I do something pretty quickly with this. No, that's not good. I mean, that's really bad. Plus THC, tetrahydrocannabinol, tested positive for 3 different things.
It's back in June. This drug patch. These are drug patches. They
didn't talk to you about this? They didn't tell you this? It says it was reported on July 23rd, a couple of weeks ago, but I don't remember seeing it, but it's highlighted in here. I mean, that's serious. This is real serious. This is about as serious as it gets.
I've been working with him.
I'm sorry.
He's just got a job.
I'm sorry, but he's got to pay for the mistake.
I understand.
Okay.
But
All right.
we've not been privy to that.
Well, I just noticed it myself. I don't know why it was sitting in there that long. But it's going to get dealt with. We got to deal with it. First thing he's going to have to do is we're going to test him right now.
Okay.
But still, that's a problem. Because I don't know what else we can do. We got him on a drug patch. I don't know what more we can do. You test positive and you go there, in there. Anyway, have a seat. We got to deal with this. The probation officer is back. Adam Dixon.
There's Ron Millie first.
Yeah.
Dixon.
Right here, Judge.
This is nice and thick.
No, for a while.
It's a bunch of motions.
Thank you, Your Honor.
Helps with the billing. Yes.
Your Honor, today, the state has made a new offer that may be dispositive. The court will remember Mr. Dixon had a lot of medical issues and was taking a lot of medication. So that's the reason why it was so. I just need a couple of weeks, 2 weeks, maybe a week. Well, I'm going to be here next week, maybe.
What's your final answer?
Please?
No, no, a week or 2. You start off with 2 and went down to 1, but
whatever is.
What do you want?
2 weeks.
You can't have that. Yeah, 2
Week
weeks.
and a half.
I just wanted to say it.
He just wants to go over, it's they've made a probation.
All right, all right. We're going to reset this 2 weeks.
Make it a one time.
Final highlight extras.
Princeton Giants.
Yeah, sure.
You've got a gaggle of stuff here.
What?
A gaggle. Gaggle stuff. A bunch of gays. More than one of them. All right, Princeton, Giles. Thanks. Yes, you're Princeton Giles. Okay, and 24 CR 1157, as you probably know, you were charged with a third-degree felony of evading arrest or detention with a motor vehicle, which carries with it up to 10 years in prison. What to do to that?
As for a short recess, 30 days, Judge.
4 weeks good? It's 4 weeks in the beginning?
That's fine, Judge.
Okay.
It's,
But this is back
Go
daylight, a Wednesday. Is that right? We'll put it in the middle of the week.
That's fine.
Is that good? Reset 4 weeks. Please get a resetting. Jarek Holman. Yeah, that's yours. You're Mr. Holman? So this man, your attorney, right?
Yes, sir. No, I thought you said.
Jared Holman. Have you ever met this man, Tom Burbank? He's your attorney. Who's your attorney for 3 years now.
I wish.
Well, you were,
I just need to get to the prosecutor, Judge. He just hired me a little while ago.
So what do you want to do today?
Just reset so I can do
2 weeks good? Is that going to be for 3, 4? I'm throwing some, what? Give me a 4's good. Okay. You got some other things on that day, so that's good. Please get a resetting. Deron Patterson.
Tom, highlighted it for me.
Anything we're going to move today or?
We got sentencing coming up, I think.
Is that Salinas?
I get to come back this afternoon. We'll move stuff in. Your Honor, we have requested this bequest on trial.
On Patterson?
Yes, Your Honor.
Okay.
We are ready. We received it.
Patterson.
Yeah, thanks. Okay. Oh, it's cell trial. And German Salinas.
That is a sentencing judge. I believe we have an interpreter here. Mr. Salinas. Oh.
There you go.
Be careful.
We now call 22-39989, State of Texas versus German Mesa Salinas. You are Mr. Salinas, Mr. Mesa Salinas.
Yes.
Do you speak English fluently? No.
No.
You speak Spanish?
Habla
español. Perfecto.
Okay.
Muy bien. Muy bien. Okay, you speak good Spanish.
Yes.
We have an interpreter. Please and state your name for the record, please, ma'am.
Erica Burge.
And Ms. Burge, raise your right hand. Do you solemnly swear or affirm that you will interpret accurately the proceedings here in this matter involving the state of Texas versus German Mesa Salinas, and you will interpret for Mr. Salinas into the language he understands most, which is Spanish, and his translations from Spanish to English And will you do that correctly? So help you God. Thank you. I think earlier in this case, the defendant pleaded guilty, correct?
That's correct, John.
Just want to make sure. Mr. Salinas, you were charged with the second degree felony of sexual assault of a child. Earlier in this case, and I believe it was we can't make this stuff up. Look at the top. Look at the date on the top of that. What was the date? He pleaded guilty. It's not on the jacket and it's cut off on the top of the page. I think it may be July 7th, but I.
Sure it was. What was that, July 7th?
Yeah, July 7th is on statement.
On July 7th, last month, Mr. Salinas, you entered a plea of guilty to this charge in this indictment 22-39989. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? The state of Texas?
Not from the state.
Defense.
The date has, the defendant has reviewed it, no changes.
It will be made a part of the record for all purposes. The agreement in this case is that whatever sentence shall not exceed a cap of 5 years in prison. So we're looking at no less than 2 nor more than 5 years confinement in prison. Is probation eligible on this? Deferred? What about regular probation? No.
Deferred.
She was 14 at the time, so it's under 14 that I think you're not. You looked at it?
Sexual assault of a child is, you can't get, I don't think the court can give regular.
No, I don't think so. I'm talking about,
It's deferred.
Yeah, you can give deferred.
You can give
what
on a second
options are available, and deferred is
none of your Catholic.
yeah. Right in front of me.
.054.
42A.102. Eligibility for deferred adjudication community. In other cases, the judge may grant, in Part B, in all other cases, the judge may grant deferred adjudication community supervision unless, and under number 2, the defendant is charged with an offense under section 2.01, which is what he's charged with. Do you see that? 42A.102. Subpart B.
Subject to B. He may grant it on 22011. And subsection B is, where's the part?
In all other cases, the judge may grant deferred adjudication unless, 1, he's charged with an offense of those, and then number 2, the defendant is charged with it's number 2, parenthesis 2, large A, is charged with an offense under section 2111, 22.011, and that's it. That's the statute.
You're talking about subsection 2 down here, the defendant's charged with?
Yeah.
And you have to go past that and it says and. As previously requested on community supervision.
And B.
Same.
Okay, yeah. That
one qualifier allows him to get deferred.
Yeah, that must means eligible. So those are the options: deferred or unadjudicated probation, or no less than 2 nor more than 5 years confinement in prison. All right, State.
Judge, this is a case where this was a consensual relationship, was known by the victim's father, evidently, according to the defendant. I don't see anything from the victim's father in here saying that, but looking at it, I don't think that the defendant appreciates this being a crime. He says in his statement, he didn't think he was doing anything wrong because everybody knew about it and he was doing it. But the child was 14 and he was, I think, 31 at the time. And that's just not legal. It's not moral. It's just not right. But taking into consideration of the fact that this was a consensual relationship, the state has limited his exposure to 5 years. But unfortunately, I think looking at this, you just can't get away from the fact that this was a child and that the child wasn't old enough to make the decision that she made to enter into a relationship with someone, and no one else protected.
The next one is not.
Court does call the case of the people versus Esther Faber.
Christina, if you're hearing for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Capper. Ms. Capper, please state your name for the record.
Esther Capper.
We're requesting an adjournment. I'm hoping to get some more mitigation information over to the people.
September 17, 2025, 9 a.m.
Thank you.
Thank you.
Thank you.
Thank you. Court calls the case of the people versus Alexis Brown.
Christina, if you're hearing for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Ms. Brown. You know, we are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So in this matter, Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney. The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that accounts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you,
I served 30 days already.
and if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
All
right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
So
Okay.
what do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess. I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you've got to make a decision, ma'am.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or not?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury, fine, that's fine with me.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post a bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by tyranny. The whole
That's-
McDonald's thing and then this and
This-
okay, let's try this one. Court calls the case People versus Deja McCoy. Is she here? Oh,
Front and center, Your Honor. Actually, she was there when I was walking out, Your Honor.
how come you didn't come back? You guys got to switch sides.
Sorry about
How come you didn't come back?
I came back, but you was gone. I figured you
I have
left the
been
bench.
here.
I
Don't
figured,
say
I figured you left the bench. I
Why
figured
didn't you
left
come
the
back?
bench.
Client was here.
When I was
And the
going
things
out.
he was saying about you, I was defending you. I want you to.
I was saying dismiss. Does it?
He was, I think, making. Okay. Reality is, I think you were making your decision because you wanted McDonald's, and you kept saying she wasn't here. That's why you didn't come back down the hallway. Isn't that right, Bert?
No, that's, no, I'm talking about when I was walking outside. We crossed each other's path.
Outside, you weren't going to turn around.
Oh, no, I wouldn't have did nothing like that.
You had McDonald's on your mind.
I would have got Coney. I had Coney on my mind. For real, but I didn't have time for it. But yes, Your Honor, Brandon Bird on behalf of Deasia Yargi McCoy. Ms. McCoy, can you please state your full name for the record?
Deasia Nicole McCoy Yargi.
Thank you. All right, what are we doing?
Respectfully, Your Honor, we just asked for adjournment to give me some time to talk about the offer with my client and to go over these videos with her.
Okay. September 3rd. Have enough time, sir?
Actually, I'm started trial on September 2nd, Your Honor, and I'm not sure if it'll be done on the 3rd.
Yeah, you look at like you. September 17th, 2025. 9 a.m.
Thank you, Your Honor.
Thank you. Have a
You
good
and
day.
Your Honor McCoy have a good day.
Okay. Did you get your food?
I did.
Okay, all right. Court does call the cases of the People versus Jay Dingman.
Conrad Siller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Dingman. Mr. Dingman, please state your name for the record.
Jay Hoan Dingman.
Thank you.
Your Honor, unfortunately, I did not have a chance to speak with Mr. Dingman. I was calling him, but however, he's in custody.
Yes.
Obviously. I believe he's being held on a felony case that is before Your Honor. I do not remember the next date. I would ask for the next possible date so I can have a full conversation with Mr. Dingman about what's going on these cases and how we can resolve them.
He's up tomorrow. Okay. And what I'll do is I'll adjourn all these to September 3rd, my next day, 2025, 9 a.m.
Thank you.
Well, I'll see him tomorrow.
And I apologize, Mr. Dingman, for not speaking with you.
Thank you. Thank you, sir. Court calls case People versus Renee Darga.
Alexander, on behalf of the people, Your Honor. Your Honor,
Okay, I'll issue an order to show cause for defendant's failure to appear. Court calls case People versus Alonzo Doss.
Alexander, on behalf of the people, Your Honor.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Doss, who should be present via Zoom.
Hello,
Mr. Doss? All right, you have a camera?
Yep, trying to cut it on. Yes, sir. Sorry about that.
Oh, there he is. Okay. What are we doing?
Thank you, Your Honor. Your Honor should be in receipt of a plea form and police report. There is a resolution in this case to which my client would be pleading no contest to an added count 2 of retail fraud in the 3rd degree, and in exchange count 1 of retail fraud in the 2nd degree would be dismissed.
Okay, that's court's full understanding of the agreement. Is that correct?
That's correct, Your Honor.
All right. Sir, please raise your right hand. You need to be someplace stationary.
Okay.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Alonzo Doss.
All right. You can put your hand down. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about it. I have to make sure that you understand. The first thing you need to understand is it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for no contest plea.
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud third degree, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
Under paragraph 5, those are your rights that are part of a trial. You understand you're giving up those rights as well as all the rights that are contained on that form.
Correct. Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Correct. Yes.
Your own free will?
Yes.
Court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-19959. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, or not counsel, but sir, I need you to understand that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea. And you would also, the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Can you elaborate a little bit on that, Your Honor?
All right. Under the Michigan court rules, there are certain things that are misconduct. Say, for example, violation of your bond conditions. Right?
Okay.
If you do that between now or between the time that I accept the plea and your time of sentencing, if there's some type of misconduct committed by you, commission of another offense, those kinds of
You are not eligible to receive that type of disposition. So it's my understanding that you're going to be changing your plea to 1 count of trespass and a habitation. Before we get to that change of plea, though, I need to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
40.
How far did you go in school?
11th grade, and I have my GED.
Can you read and write okay?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you in this matter?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you've received from Ms. Shy in this case?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take any type of medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document. This document is called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes.
And you believe you understand what it says?
Yes.
This document says you're entering a plea of guilty to 1 count of trespass and a habitation as a felony of the 4th degree. That carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
In addition to that penalty, you're also subject to a discretionary period of post-release control which means that if you are sent to prison, upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you are sentenced to. Do you understand that?
Yes.
But it's not mandatory that you're sent to prison at all. The court does have the discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes.
You are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury must find you not guilty, and their verdict has to be unanimous. Do you understand that? Understand that?
Yes.
At that trial, you have a right to see and hear all the evidence that the state has against you with the help of Ms. Shai, the right to confront and cross-examine each of the prosecutor's witnesses. Do you understand that?
Yes.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes.
You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reasonable doubt. The standard applies to each of the essential elements of the charges from the indictment. Do you understand that?
Yes.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed and try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes.
This is how you want to proceed?
Yes, sir.
All right, Ms. Tranter.
On or about the 17th day of April, 2025, in Moore County, State of Ohio, Joshua Thomas Bird did by force, stealth, or deception trespass in a permanent habitation of another while the someone other than the offender or accomplice was present or likely to be present.
Ms. Shai, anything on those facts?
No, thank you.
Mr. Burt, did you hear the statement that she read?
Yes, Your Honor.
Do you acknowledge what she said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes.
What is your plea?
Guilty.
All right, the court's going to make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. It's my intention to proceed directly with sentencing. Since I have this ILC assessment, I don't need an additional pre-sentence investigation. Ms. Tranter, anything on behalf of the state?
No, nothing further, Your Honor.
Anything from probation?
Nothing further, Your Honor.
Ms. Shai?
Nothing further.
Mr. Burt, anything you'd like to say?
It was like I've been out of trouble for a while, and like I stopped doing what I needed to do to stay clean, and I had a relapse, and it was very miserable, and it is not worth it. In a 9-year process, I learned what it was like to live a full life, and it was misery, like it was a mistake, and like my recovery will come first. And thank you.
Okay, thank you, sir. The court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court does find that you are amenable to community control, so I'm going to place you in the community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You are ordered to refrain from the use of any drugs, alcohol, or THC. There's no marijuana use in any form. Do you understand that?
Yes, Your Honor.
Especially considering, Mr. Burt, I would guess I'm going to describe this as a fragile mental health state at this time. The marijuana is just, it's really going to long-term destroy your mental health. Okay. I know that you are already engaged in treatment, and I'm going to order that to be continued. I do want an additional assessment done to rule out any specific mental health disorder diagnoses, okay? So I want to get that assessment, but you can arrange that through court services. You're to have no contact with Kristen Northcutt. Do you know this person?
No, Your Honor.
Okay, so that should be pretty easy for you to stay away from her, right?
Yeah, I don't even know where the house is.
Okay, good.
Can't remember.
All right. The court is, you are employed full-time, it looks like, right?
Yes, Your Honor.
All right, I'm going to order you to continue that, and I want you to successfully complete the Thinking for a Change course. All right, you have 28 days jail time credit as of today. As we just spoke about, you're also subject to this discretionary post-release control. It has to do with getting sent to prison and being released. Do you want me to go over that with you again?
No, Your Honor.
Okay. You do have a right to appeal. The court. I'm going to find right now. I'm going to make a finding that you're indigent for the purpose of any fines, costs, or other financial sanctions, understanding that you're working, but I have put a lot on your plate right now, which I think is sufficient. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have any questions for me?
No, Your Honor.
All right, you started off good here, so let's just keep this moving forward, okay?
Yes, sir.
Ms. Tranter, is there anything else?
Nothing further,
Ms.
thank you.
Shy?
No, thank you, Your Honor.
All right, Mr. Burke, good luck to you, sir.
Thank you.
All right, see ya. Thank you, Judge.
The only thing that, in addition to that, and I was reading the notes on this, and it is true, alcohol was involved in this. I'm assuming that is a standard rule of probation.
Yep, he's going to do the outpatient drug and alcohol treatment.
And then there was concern on mental health as well. I don't know if there would be any component of that, like an assessment.
I think that substance abuse is probably our strongest, having reviewed the PSI, but if we need some counseling or anything, we can get that set up.
Thank you.
All right, so Mr. White, if you violate the terms of your supervision or you leave the state without permission, I could sentence you to up to the maximum penalty in this case, which is 18 months in prison, plus an optional period of post-release control of up to 2 years. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript or to pay the cost, they'll all be provided to you without charge. Good luck to you. Do you need a minute with Mr. Hopkins, Mr. Gibbs?
If possible, yes, Your Honor.
Then what would end up happening, sir, is that the court would no longer be bound by any sentence evaluation. There really isn't one in this case, but also you would not be entitled to withdraw your plea.
Okay, so I'm sure other than breaking the regular laws and something along these lines that got me here, outside of that, is there anything else?
Mr. Doss, it's pretty much if you continue your compliance on bond and you don't commit any alleged offenses, that should not come into play. But in this case, you don't have a sentence agreement anyway.
Okay, like basically what I'm getting to, if y'all don't understand, is like when you're on probation or parole, you have certain stipulations that you can't, or on bond. I was trying to make sure that there wasn't any specific, like other than me not stepping foot in that location, is there anything else that I should be aware of?
Nothing new or additional since we last spoke, Mr. Doss.
Okay.
Okay, do you understand what I just told you?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor. Not that I'm aware of, Your Honor.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2, the retail fraud 3rd degree. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
August 27th at 12 noon.
August 27th, 2025, 12 noon. All right, sir, you need to hang on the line. I have probation intake on the screen. We're going to put you into a breakout room so we can get the process started, okay?
Yes, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Mr. Doss.
Court does call the case, People versus Gibson, Stefan Gibson.
Assistant Public Defender Natalie Tate with and on behalf of Mr. Gibson, who is approaching. Please state your name for the record, sir.
Devin Gibson. All right. I have before me a plea form that indicates that the defendant would be pleading no contest to the charge of assault and/or assault and battery. The 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's understanding of it.
That is correct, Your Honor.
All right. May I have him sworn, please?
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so we got.
Yes.
Lower your name and state your name.
Devin Gibson, DEVONGIBSON.
All right. Mr. Gibson, it's this court's understanding that you're going to plead no contest to the charge of assault and/or assault and battery. That's a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about it I have to make sure. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty.
I mean, I do admit I do have a drug problem, but I've never once been seek treatment.
So you want to go to a CBCF? Is that what you're telling me?
Yeah, I mean, I would love to go to see. I want to give something else a try because obviously I've done jail time after jail time after jail time and nothing is working. I mean, I'm just asking for a shot. That's it.
Let me make sure that I understand this, Mr. Hopkins. So you got 6 months to do for Judge Parker in Montgomery County.
Yes, sir.
After you get done with that 6 months, then we start the CBCF and get you into a drug treatment program. Is that the Hopkins plan?
I mean, I was gonna try to because he ran my time with this time, so I didn't know. I was wanting to try to go to CCC or something, you know, because these are the programs that I've heard that are around here in this area that are good. That I don't really know because I've never been to one. So.
Well, I mean, I think that a community-based corrections facility is probably the best outcome for this, Mr. Hopkins, but my hands might be kind of tied because of what's going on in the other jurisdictions.
Okay.
Let's try this. Let's reset this in a couple of weeks because we don't have a CBCF evaluation, right? So let's do that because we have to do an ORAS too, right? Because we just did a level 3 or 4, whatever it was. So we don't have the information. Let's do a referral to STAR and CCC. Let's set this for sentencing in 2 weeks. And Officer Wolford, if
he was offered treatment, just so you know, in his OVI case, but that's why.
What OVI case? You talking about with Fairfield? They sentenced me to it, but they never came and evaluated me. And because I was under an indictment there, whenever they no-billed me, you guys had came and picked
like I
me
said,
up.
a CBCF is still a good option in this case, regardless of what's happened in the past. Ms. Hyatt, can you just make a copy of Judge Parker's entry for me?
Sure.
And I will reach out to his office. I don't know that he even has the ability to revisit his sentence now that it's been issued. Don't think that he has the ability to make a sentence concurrent to a sentence that does not exist either. So we have a mess on our hands procedurally, but we'll see if we can get it worked out.
Okay.
And we'll see everybody back here in a couple of weeks.
Sure.
Okay?
Thank you.
You understand that?
Yes, sir.
All right. Still wish to plead no contest?
Yes, sir.
Basis for no contest plea?
Potential civil liability, Your Honor.
And sir, to that charge, how do you plead?
No contest.
You understand? That's all right.
Okay.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form. Is that correct?
Yes, sir.
Any question about any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Mm-hmm.
Yes?
Yes, sir.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 25-29070. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, are you, sir, I do have to advise you that if you commit misconduct between today's date and the time of your sentencing, as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and you would also not receive the benefit of any sentence. The court would not be bound by any sentence recommendation or evaluation. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor. No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
August 27th at 12 noon.
August 27, 2025, 12 noon. All right. Probation will be down to see you and try to get everything all set. All right, sir.
Okay, thank you.
Thank you, Your Honor.
Bond continue. Court does call the case, the people versus Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
You have to start there. They're not. All right, hold on that one. The court does call the case people versus Carlisle Travis.
Alan Zend on behalf of the people, Your Honor. Assistant Public Defender Natalie Pate for Mr. Travis. Your Honor, I do not have an explanation for his failure to appear. I did not have a phone number that was working for him. Unfortunately, he did not respond to an email that was sent by our office. I would respectfully request an adjournment for the record. I don't have any other further explanation.
Bench warrant 5,000. Give it 10% privilege. I'll have those warrants issue immediately. Well, I'm not going to have it issue immediately. I'm going to give. What is 1 week out? The 13th.
The 13th.
I won't have those warrants because of the absolute screw up regarding the JAS issue and you contacting your client. I won't have those warrants issue until August 13th.
Thank you, Your Honor.
Call the case people versus Devon Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
An Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez. Please state your name for the record.
Devon Julia.
Hi. Thank you, Your Honor. I'm respectfully requesting both an adjournment and if the court would consider a possible release to treatment for Ms. Martinez. I can provide Your Honor with an order. It is my understanding she is still being held on her felony matters, but she is hopeful that she can get a release to treatment on those cases as well. So I'm making that request on her behalf as well as asking for an adjournment.
Excuse me, I'd also like to keep the $500.
I'll adjourn this to September 3rd, 2025, 9 a.m. And any objection from the people about release to treatment?
No, Your Honor.
Then if you submit an order to the court, I will sign that order.
Thank you, Your Honor. And my client is asking for clarification. Is her bond currently $500? However, she would not have to pay that to be released to treatment, correct?
I
would release her to PR on a trip. I would release her on a PR to go to treatment.
But $500.
But if she doesn't complete treatment, and we've been down that path before, she comes back.
Understood, Your Honor. So,
but there is still
the judge just gave you a PR to be released to treatment.
But does the $500 bond still exist? Is it there? So is it also? Yes.
If that is what your bond is currently a PR to treatment. but you would be still getting credit for your time in custody.
Okay, can we keep the $500 bond as well?
Well, it'd be a $500 bond until they find treatment, then it will transform into a PR so you can be released to treatment.
Okay, so, but it still is a $500 bond if.
Right now,
That's
yes.
right.
Okay, thank you.
Yes,
Thank
but this
you.
will not hold you up from going to treatment.
Okay, thank you. So can I?
Thank you, Your Honor.
Yep.
Let me step back.
You gotta keep going, Ms. Martinez, gotta keep moving. Apparently, that's your fault too. Court calls the case, People versus Paris Lester.
Conrad Siller on behalf of Pittsfield Township.
And then on behalf of the people,
The public defender Lauren Perry on behalf of Mr. Lester. Your Honor, I did provide the Zoom information to Mr. Lester. I did not have contact with him. As of Friday, we knew he was in the hospital. But as of now, I do not know where he is.
Paris Lester. Being no response, a bench warrant will issue for defendant's failure to appear. Again, because of the mess up with JIS and the information, I'll set bond at $5,000. I'll give a 10% privilege. However, that warrant will not issue until August 13th, 2025. See if you can locate your client since they cut off access to your information. Oh, by the way, so that we're also aware, whatever this, trying to be nice about it, try not to use bad words. This whole thing regarding JIS, there's also now a hiccup with community corrections because they no longer have access.
Judge, I can't handle any more hiccups this week.
Of course, because as Perry often thinks, it's all about me.
So Your Honor, if I was gonna contact SCAO to see if I could get JIS access, that probably wouldn't be a good idea right now.
Oh, you can absolutely contact them, but if you get access, they apparently just give it random to whomever and then take it away. I don't know what they're doing, but I don't know. I mentioned that only because I'm not sure what hiccup that may cause with the orders. Like the last block, I had a number of those SoberLink orders, but I don't know that they can complete it without some additional information. So we're trying to fill the gap because we don't have enough to do. And God forbid they be able to find a date of birth on a computer, right? Okay, I'm done for now. I'll come back to it. Court does call the case, People versus Anthony Miller. It's the stupidest thing in the world. Information is just.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Miller. Good morning, Ms. Miller. State your name, please.
Anthony Lavelle Miller.
Thank you.
Your Honor, two things regarding the pretrial. I'd asked for an adjournment. Mr. Miller would like to do some additional investigation,
Okay.
and he would like me to address his bond.
Okay. Why don't you, how much time will it take you to do can you do that by the 3rd?
I think so, Your
Okay,
Honor.
all right.
Thank you.
So I'll adjourn the pretrial to September 3rd, 2025, 9 a.m.
Regarding his bond, he just saw, Your Honor, on Thursday on a felony. You did modify his bond to a personal bond because the public defender that represented him then provided, Your Honor, with proof of incarceration. That is why he missed his felony PCC. He has $100 bond on this case. We're asking for a personal bond to be released on this one. I have the proof of incarceration as again, that was provided.
Where's he gonna go if I?
The Lina Center.
When his pretrial that he missed on this file was the 18th, he was incarcerated at the Wayne County Jail, according to the sheriff there, on September 17th of last year. So again, he's asking for a personal bond. I did get a good phone number for Mr. Miller. He does have a phone, so if and when he's released.
No, you keep going. I've already made my decision, but go ahead.
Well, we'll
I
communicate
just like
that.
hearing you talk. Go ahead.
That's all I have to say.
That's all you have to say? Okay.
That's it.
Bond is reduced to a personal recognizance, $5,000.
Thank you, Your Honor.
Thank
I'll
you.
call this one.
Have a great day.
You do the same. Make sure you come back.
Sure.
Court call. Yeah, make friends.
He's happy.
Is he?
Yeah.
It must have been something you did. Court calls the case people versus Sierra Peterson. Then I'm down to, that's my last one.
And then on behalf of the people.
Conrad Seller on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate for Miss Peterson, who I hope is present via Zoom.
Sierra Peterson. You think she's the Motorola? Tara Peterson.
Hello.
Hello, what's your name?
Hello. Kurt Bushline. I'm
Okay,
trying to
that's
do
not-
this, Your Honor. I'm trying to figure this out.
Okay, no, you're good, but I didn't call your case.
Okay, I can't see you. That's why I was trying to figure this out.
You can't
Your
see me? Yeah,
Yes,
that's
sir.
not a great loss.
Honor. Okay, I'm sorry.
All right, so just hold on. We'll get to your case at some point, I'm sure.
Okay, all right. I'm
When is
sorry.
he set for? What's your name again?
Kurt James Bushline, Buschlein.
Sam.
Kurt, Kurt.
Are you sure you're supposed to be before me?
Yeah, 10 o'clock. I'm supposed to be there at 10 o'clock.
Okay, you gotta be before Magistrate Odetella.
Okay, well, it said you, sir, on the paperwork, so I don't know. So
Yeah,
how do
I
I
know.
do this then? How do I do this?
All right, so we'll get, yeah, you need to call our clerk's office so they can give you the Zoom information, okay?
Okay, yes, sir. So we'll go off this and call the clerk's office.
Yeah, you want the phone number?
Yes, what is it? 973-4545?
Absolutely.
Okay, sir. Thank you and have a blessed day.
Thank you. You too. Okay, now back on Tierra Peterson.
So, Your Honor, I left a voicemail at one of the numbers I had for her. She did appear via Zoom for the last hearing. However, she didn't return my call, and then an alternate number I had for her was now disconnected. I have not had a conversation with her since the last hearing. I don't have an explanation for her failure to appear, I guess is the bottom line, but I'm respectfully requesting an adjournment.
Bench warrant, 5,000, give 10% privilege. Warrant will not issue until August 13, 2025, JIS.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Kerry Wynn.
Conrad
And then
Seller.
on behalf of the people.
Oh, just, yes, state please. Okay, thank you.
Hi, Alberto, on behalf of Mr. Nguyen. Mr. Nguyen, please introduce yourself to the court.
Kerry Wynn. What are we doing?
Your Honor, at this time, people are unable to proceed on this case. I would ask for a dismissal.
Of course, without objection from defense.
All right, this case is dismissed.
Thank you, Judge.
All right.
Well done.
Court calls case People versus Sean Charnley.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Charnley. Take your name for the record, please, sir.
Sean Arthur Charnley.
Your Honor, we have come to a resolution. I did provide a plea form and an advice of rights form, but I also have hard copies for the court if needed.
I have.
Great. So the agreement is that he'll be pleading guilty to an added count of retail fraud third with also with a further agreement to pay full restitution.
Right. That's the court's full understanding of the agreement. May I have him sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so we got?
I do.
Lower your hands, state and then spell your name.
Sean Charnley, SeanCharnley.
Mr. Charnley, it's this court's understanding that you're going to plead guilty to the charge of retail fraud, third degree. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
I do.
Still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I have.
Any question regarding any of those rights?
None.
Look at paragraph 5. You'll see a copy on the podium.
I do.
Those are your rights, which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Nothing.
Anybody threaten you or coerce you?
Not at all.
You're doing this voluntarily?
I am.
Of your own free will?
Absolutely.
Because you believe that you're guilty?
I am.
May 14, 2024, at the location of 7000 East Michigan Avenue, that being the Walmart, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I took items that didn't belong to me and didn't pay for them.
And tried to walk out of the store?
I did walk out of the store.
You walked out of the store with them. Okay. Store was open to the public at the time?
It was.
You didn't have anybody's permission to take that property?
I did not.
And this property you took was offered for sale by Walmart?
Yes, it was.
All right, counsel, have I complied with the court? Well, before we get to that. Sir, I do have to advise you, if you commit misconduct as defined by the Michigan court rules between the time of this date and the time of your sentencing, your plea and your sentencing, you would not be entitled to withdraw your plea, and you would also not be entitled, or the court would not be bound by any sentence recommendation. You understand that?
Yes, I do.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred.
Your Honor, I did want to address that.
Okay.
He does have 138 days credit in the Washtenaw County Jail. I would ask for immediate sentencing if the court is amenable to that.
You have an agreement regarding restitution. So somewhere along the lines that has to be figured out.
I did want to also put on the record the amount for the police court is $368. So that's the amount that I reviewed with Mr. Charnley and he's agreed to pay. I don't know if Ms. Sister counsel.
Is this the only thing holding him?
No, Your Honor.
So he's going to be in it anyway?
Yes.
Okay, then. So if I release him on this, he's not going anywhere?
No, no.
Are we done?
Yes, Your Honor.
Okay, good. I'm going to refer him to probation for pre-sentence investigation and report, as well as determination for sure of the restitution involved. Sentencing will be
August 27th at 12 noon.
August 27th, 2025, 12 noon. All right.
Thank you.
Thank you. Yeah.
Okay.
That's the limit. Okay. And then I'll call him. Court does call the case People versus Michelle Campbell.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Campbell. I'm sorry.
Michelle Campbell.
Now he's on behalf of Your Honor.
And so that you know, I've slipped into the 11 o'clock block to balance against. That's why you're not saying it.
Your Honor, I did attempt to make contact with Ms. Campbell. However, we don't have any good contact information for her, so I was unable to actually make contact with her. For the record, I'd ask for an adjournment.
Bench warrant 5,000, 10%. That warrant will not issue until the 13th of August. Court does call the case People versus Ashley Fix.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Patewith, and on behalf of Ms. Fix, please state your name for the record. Ashley Ann Fix. Thank you, Your Honor. I believe we are very close to a resolution of this case. I have gotten Ms. Fix to sign the release of information for me to get her CMH records so that I can provide them to the prosecution to resolve this case. I'd be asking for one last brief adjournment.
The next date is September 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Time continued. Thank you. Court does call the case People versus DeMar Ficklin.
Christina Bergeron for the people.
DeMar Ficklin.
Yep.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Ficklin.
Can you state your name, please, sir?
Yep, DeMar Ficklin.
Okay. I need a camera, please. What are we doing?
Sorry about that.
Your Honor, we have come to a resolution.
Yes.
Provide a plea form. Mr. Ficklin is going to be pleading as charged under HIDA.
All right. Okay, sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
DeMar Ficklin.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of embezzlement by an agent or trustee less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
You understand that the fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine.
Yes.
All right. And understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
So my plea would be so while I was working at
Hold on. How do you plead? You pleading not guilty, guilty?
No contest.
Mr. Ficklin, if you want to plead no contest, we have to do some more paperwork, so we won't be able to do that today.
Okay, no, we can go with the guilty. I'm sorry. Yeah, we're going with the guilty.
Okay, so the judge will ask you for a factual basis in a little bit. We'll get into that, but for now, just answer the question he's asking. So you plead guilty or not guilty?
We plead guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
You signed an advice of rights form with permission. Is that correct?
Yes.
Do you have any questions regarding any of those rights?
No, sir.
You understand that you're giving up all of those rights, including the rights contained in paragraph 5, which are your trial rights?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
Between the dates of October 4th, 2024 and October 18th, 2024, location of 3825 Carpenter Road, were you an employee at Meyer?
Yes.
And during that period in time, what did you do that makes you think that you're guilty of this offense?
Well, when I was there, I did grab a few paper plates, maybe a pizza, and a soda, and I guess took it to our back area where we store our stuff and bring it out to our customers, the department I work in, and so yeah, that's it. I
So
guess.
you took things from the store, took them to a back area, and then you ate them?
No, well, no. Took them through the back area. Yeah, like the back door area. There's to get out the store. Yeah.
Okay, what'd you do with the stuff that you took?
Oh, well, it was really family things really that feed my little brother, my sister.
Okay. So you took them out and used them for your own personal use?
Yeah.
Yes? Okay. And you came into possession of that by the fact that you were an employee at Meyer?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
All right. I think we've got it, counsel, because I don't think I need a dollar amount. Sir, I do have to advise you that if I accept your plea and you commit misconduct as defined by the Michigan court rules between the time of this plea and the time of your sentencing, you would not be entitled to withdraw your plea, and you would not be, the court would not be bound by any sentence recommendation. You understand that, sir?
Yes.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count one. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
August 27th at 12 noon.
August 27, 2025, 12 noon. And sir, I want you to wait on the line. I'm going to put you into a breakout room with my probation department so we can start that process.
All right.
Okay, thank you.
Thank you.
Where have you been? Court does call the case of the people versus Matthew Fonseca.
Conrad Solar on behalf of Pittsfield Township.
Nesca.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Fonseca.
Your Honor, we are asking for another adjournment on this case, or this case is Mr. Fonseca has pending felonies. There was another one that was recently arraigned on. We're trying to get a global resolution. I believe they're all before Your Honor still.
Okay. When's he next up before me on that docket? Do you
Is
know?
it the 14th?
I'm not too sure.
14th, maybe?
Sounds right.
I think it's the 14th.
Okay. I'll adjourn these to September 3rd, 2025, 9 a.m. That's my next date. Okay.
Thank you.
Bond continued.
There ain't no new phone, is there?
Thank you.
There ain't no new phone.
Oh, the one you already read.
Court calls the case of the people versus Brian Foley. You don't have to close those out?
That is it on behalf of the people, Your Honor.
Pardon?
I have this listed as no counsel, I believe Mr. Foley.
He's here.
Yes, gentleman in the back.
Mr. Foley?
Sir.
Hmm?
It will have to be like this.
Let's take a look. Okay.
On me, yes, Your Honor.
All right. State your name.
Brian Foley.
All right. Mr. Foley, you're not represented by an attorney, right?
Correct.
All right, what are we doing on your case?
I had a unpaid traffic ticket, which I have since paid from out of your courtroom.
Okay, hold on. You're here on a DWLS, a driver license suspended. And I see what you're saying. So what you're telling me today is that your license is now valid.
Correct, Your Honor.
All right. I can verify that his license is valid.
Then the people who did this, Your Honor.
He did that all on his own? He didn't want an attorney and he got his case dismissed? Take Mr. Foley out. All right. Yeah, I'm sure you don't have any objection to the dismissal.
I don't, Your Honor.
All right, this case is dismissed.
Yeah, I know not to come before you unprepared.
Is that right? Yeah. All right, Mr. Foley, got it? Okay. Foley, you take care of yourself, sir.
Your Honor.
Court does call the case, People versus Daryl Frederick.
Conrad Siller on behalf of Pittsfield Township.
Sorry. The Assistant Public Defender Natalie Pate with and on behalf of Mr. Frederick, who stands to my right. Please state your name for the record, sir.
Daryl Frederick. All right, what are we doing?
Thank you, Your Honor. There is a resolution in this matter to which my client will be accepting responsibility to double parking, and in exchange, the misdemeanor charge will be dismissed.
That is correct, Your Honor. So I move that count 2 double parking. If you accept that admission, move to dismiss the original charge.
You admit responsibility to the fact that you double parked a motor vehicle on or about May 30th, 2025 in Pittsfield Township?
That is correct, Your Honor.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. I'll make that due 90 days after release. All right.
Thank you, Your Honor.
Thank you. Thank you. You were down there. We were looking all around for you. We thought we lost you. Court calls the case, People versus Chad Jones.
Conrad Siller on behalf of Pittsfield Township.
And Aaron Zinn on behalf of the people, Your Honor.
We're doing it.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Jones. Jones, please state your name for the record.
Chad Jones.
All right, what are we doing?
Your Honor, we are requesting adjournments on these as well. Mr. Jones has felonies that are currently pending, as well as we are hoping that he will be released to treatment relatively soon here. I did get information from Patrick at the jail that he's hopefully set to be released relatively soon, and I think that will help resolve what he's got going on.
And we signed the necessary orders on these cases.
Yes.
For that, okay. Okay, I'll adjourn it into September 3rd, 2025, 9 a.m.
Thank you.
All right, thank you, Mr. Jones. So you can look at this. Court calls the case, People versus Jessica Fox.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Fox. Your Honor, I did attempt to make contact with Ms. Fox. I was not successful. I'm not sure if she's on the Zoom. She is.
Yeah, I'm
She
here.
is. All right, I need a camera, Miss Fox.
Yeah, I don't know why. There it goes.
Okay.
Okay.
There we go. Okay, what are we doing?
You know, there are ongoing plea negotiations going on. I'm asking for an adjournment so I can have another conversation with Ms. Fox. We weren't able to have one prior to today.
All right, September 17th, 2025, 9 a.m.
Okay, thank you.
Thank you. Court calls case, People versus Micah Jones.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
Micah Jones. Hey, what are we doing?
Your Honor, I guess we don't have an agreement on this charge, but Mr. Jones is going to be pleading guilty as charged to the retail fraud third. From my understanding, in my math, is maxed out on this charge. I do have a signed plea form and an advice of rights form as well.
Okay. And do we know if there's any restitution?
I don't believe so. I think everything was recovered.
Okay, well, they looked that up. Can I have them sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Lower than spell your name.
My name, Micahjones.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud to third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole?
Yes.
You are?
On probation.
All right. Were you on probation at the time of this offense?
I believe so.
All right. I do have to advise you, this could be considered a violation of that probation.
Yeah. Judge Washington said something about it.
Pardon?
Judge Washington, she said something about it.
Okay. You understand that if it is considered a violation of that probation, you could be sentenced to the maximum allowable under that other charge. And understanding that, you still wish to plead guilty to this charge?
Yes.
Anybody promise you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty?
Yes.
All right. Let's see. July 2nd, 2024, it's location of 3825 Carpenter Road, that being the Meyer, Pittsfield Township, Washington County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I did retail fraud.
The retail fraud. Okay. You went into Meyer.
One of Myers, I stole a few items.
And you took some items.
Yes.
All right. You tried to walk out without paying for them?
Yes.
All right. Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
And these items that you took were offered for sale by Meyer?
Yes.
All right. Sir, if I do accept your plea, I do have to advise you that between your plea and the time of sentencing, if you commit misconduct that's defined in the Michigan court rules, you would not be entitled to withdraw your plea. And also you would not be entitled, since there is none, to any sentence recommendation or evaluation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes.
Court will accept the defendant's plea of guilty to this charge. All right. How long has he been in?
We did the math since he was arraigned. Has
April. I have an April arraignment date on this case.
I'm sorry, we did the math together, Mr. Jones and I.
Okay, but I'll trust Mr. Jones' number. I've seen you do math.
No, I know. Well, okay, so since his arraignment, he has 24 days, I believe, but since the date of the offense, he has I think 100 days.
Where are you getting this 20 days? Was he out for a period?
He was in from October 7th, 2024 to December 6th of last year, then back in February 13th, 2025 to April 8th of this year. And then he's been in for 23 days. He was booked on July 15th, 2024.
So how many days do you have for him? I thought you guys did this.
Okay.
I know, we did it yesterday.
No.
Okay, no, I think Perry should have to do the math.
Oh, I have 133 days since the date of the offense here. That was 6 days ago. I'm sorry, I should have had.
You're right. You are absolutely right. I was just gonna wait, see if a miracle happened. Sir, is there anything you want to say before I approve sentence?
No, I apologize for what I did. I said I'll never do it.
Pardon?
I promise them not to do that again.
$125 statutory fee, 93 days in jail, credit 93 served. You're all set.
Thank you so much.
Take care. Court does call the case of the people versus Vincent Lambert. Well, no, not yet. Court does call the case of the people versus John Funch.
And then on behalf of the people, Your Honors. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Funch. Mr. Funch, state your name for the record.
John Michael Funch.
No, there, you got it.
Yeah.
Okay, what are we doing?
Hello?
Well, Your Honor, we do.
Hello?
Hello? Hello? I'm here.
Hello? Okay, we got
Hello,
you.
sorry.
Okay, all right, hello.
Hello,
We do
I'm here.
have- We did,
Okay, yep, we got you.
we do have a plea agreement, however, Mr. Funch, you have to have camera to do a plea. And he's here on phone.
Oh, I don't have a computer though. That's the only thing.
I have to come down.
I'd ask for an adjournment so we keep, and I'll speak to him about coming in person or
Okay.
coordinating
No,
another.
hold on. My grandson's got a computer. Give me a minute. I can use his. Okay. Hold on. Just give me a second.
That's his grandson.
Sean, can I use your computer? I'm on court. And can you set me up on the Zoom? Well, I just need to, I know how to dial in it. You just need to use your computer. Come on, hurry up. I'm in the court meeting right now.
Your brother, would you mind passing it and maybe he can get on the Zoom today? And we can start the sentencing
Yeah,
process.
I can get it hooked up. If you can give me a couple minutes here, I can get it hooked up. This is embarrassing. He's got it.
I'll pass
right
it,
here.
I guess. He's going through that much effort. Court does call the case, people versus Vincent Lambert.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Lambert. Mr. Lambert, please state your name for the record.
Vincent Lambert.
Your Honor, we're requesting adjournments on these cases. Mr. Lambert is also being held on felony files. And we're doing a little bit of investigation on this case as well.
When is felonies out?
Do you remember
Next.
Where are they at?
when the next court date is?
Sometime later this month, in like a week or two, I think.
That's not before me. That's actually in circuit.
No, there's one in front of you first. There's
Got
four felonies. In front
Got it. Okay. So let me put these out then. I'll adjourn these to September 3rd, 2025 at 9. Let's see if we can get all those resolved.
Thank you.
Okay, thank you, sir.
Fantastic.
Court calls case people versus Ashley Garcia.
Defender Natalie Pate for Ms. Garcia, who may be present via Zoom.
Garcia? Yeah.
Your Honor, I do have a phone number for her that I was able to leave a voicemail at.
Ms. Tranter, does the state have a position?
Yes, Your Honor, we would object to a bond at this point, given Mr. Hudson's history. My fear is that if we release, his medication would not be administered in the proper dosage at the proper time. We've already had to have a forced meds hearing on Mr. Hudson one time. And my fear would be that he would decompensate and then we'd start this cycle all over again. Trial is next week. We're not looking at an extended period of time. So we would ask that he be held at this particular point.
All right, I'm going to set Mr. Hudson's bond. Let me look at this real quick. Just reviewing the bond report that was previously submitted. Looks like the previous bond was $10,000 cash or surety. I mean, based upon Mr. Hudson's previous record, I mean, that looks like to be an appropriate bond. He certainly, this is not a recognizance case with the significant record that he has. But I will maintain it at $10,000. He can do that with cash, surety, or 10%. All right, thank you all.
Thank you, Judge.
5 CR 42819, the state of Ohio versus Chad Fields. Mr. Fields is before the court with his counsel, Mr. Getty. Mr. Harris is here on behalf of the state of Ohio. First thing we must do, Mr. Fields, is you have now been indicted a second time by the Warren County Grand Jury under case number 25 CR 42819. Have you received a copy of that indictment?
Yes,
When did you receive that?
today.
Okay. You have a right to wait 24 hours before you are arraigned on that indictment. Would you like me to reset this for an arraignment, or you want to waive that and take care of it today?
Take care of it today, please.
All right. This indictment charges you with one count of aggravated possession of drugs as a felony of the 5th degree, and that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The second count is one of possession of drug paraphernalia, a misdemeanor of the 4th degree. That carries a maximum penalty of 30 days in the Warren County Jail and a $250 fine. At this time, what I'm going to do is just, at least temporarily, I'm going to enter a not guilty plea on your behalf for purposes of the arraignment only, and then we're going to get into the second part of this hearing. Okay, sir?
Okay.
And again, we'll just show on the record that he's granted an OR bond, Ms. Tranter, on that new case.
Okay.
All right. So that takes care of that. So what we've done then, Mr. Fields, is on your new case, Mr. Getty has also filed a motion for intervention, move conviction on that case, as well as your previous pending case. So in a moment, you'll be asked to change your plea to guilty. It looks like to a total of 3 counts. There's 1 in the first charge, or first indictment, the 2 counts I just read in the second indictment. What happens is then that the court accepts your plea but does not make a finding of guilt. Instead, I'll hold your plea in abeyance or set it aside and require you to complete a plan of intervention. Okay. If you successfully complete that plan of intervention, then the prosecution of this case will end with no finding of guilt, and I will dismiss all these charges against you. Do you understand that?
Yes, sir.
The other side of it is that if you fail to complete the plan of intervention, if you continue to use illegal drugs or you break the law, the court will be able to make a finding guilty that's based on your plea today, and then I'm going to sentence you on these charges. Do you understand that part of it?
Yes, sir.
All right. How old are you?
38.
And how far did you go in school?
I completed 12th grade.
All right. So you can read and write.
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you if you fail to complete ILC?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Getty in this case?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take any type of medication that interferes with your ability to understand what's going on today?
No, sir.
Okay, I have in front of me 2 sets of documents. There's a set for each of the indictments. We're going to talk about the 42601 first. On the second page of this document, on the line marked defendant, there is a signature. Did you sign this document?
Yes, sir.
And you read it and went over it with Mr. Getty?
Yes, sir.
And you believe you understand what it says?
Yes.
This document says you're entering a plea of guilty to 1 count of aggravated possession of drugs as a felony of the 5th degree that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
And then under case number 42819, Again, on this document, on the second page, there's a signature. Did you sign this document?
Yes, sir.
And you read this document and reviewed it with Mr. Getty?
Yes, sir.
And you believe you understand what this document says?
Yes, sir.
This document says you're running a plea of guilty to one count of aggravated possession of drugs. Again, as a felony of the 5th degree, that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. This prison term is not mandatory. The second count is one of possession of drug paraphernalia, a misdemeanor of the 4th degree, carrying a maximum penalty of 30 days in the Warren County Jail and a $250 fine. Do you understand the maximum penalties involved with this case?
Yes, sir.
Under both cases, you're subject to a discretionary period of post-release control. And that means if you are sent to prison on either of these or both of these, upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you are sentenced to. Do you understand that?
Yes, sir.
But as I've said, it's not mandatory that you're sent to prison at all, even if you fail to complete ILC. The court still has the discretion to place you into community control, or what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
Now, you are presumed innocent of all of these charges, and you cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury must find you not guilty and their verdict must be unanimous. Do you understand that?
Yes, sir.
Now, at that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. Getty, the right to confront and cross-examine each of the prosecutor's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury. They are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictments. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed, and you could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you will be waiving all these rights? There will not be a trial.
Yes, sir.
That's how you wish to proceed.
Yes, sir.
Mr. Harris?
Yes, Your Honor. Regarding case number 25 CR 42601 and as well as 25 CR 42819, if these matters had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, first to the one ending in 601, that on or about July 29th, 2024, defendant Chad Fields was found in possession of methamphetamine at 0.16 grams. That was in the city of Lebanon, Warren County, Ohio. And regarding case ending in 819, this was on or about February 9th, 2025. City of Lebanon, Warren County, Ohio, defendant Chad Fields was found in possession of 0.06 grams of methamphetamine, as well as a pipe used to smoke methamphetamine.
Mr. Getty, anything on those facts?
None, Your Honor. Thank you.
Mr. Fields, did you hear the statements that he read as to each case?
Yes, sir.
Do you admit and acknowledge what he said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we discussed.
Yes, sir.
What is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty. As to each case, the court is going to grant your motion for intervention and move conviction and order these proceedings stayed pending the completion of the terms of that supervision. So starting out, you'll be on ILC for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You are ordered to refrain from the use of any drugs, alcohol, or marijuana. There's no THC in any form. I'm ordering you, I know you've completed the coach. Are you in the IOP program now?
No, I actually completed IOP. I completed all my treatment. I've been sober for 6 months off everything. And I go to counseling at the coach once every 2 weeks, and I go to church and recovery meeting every Tuesday night.
Officer Bridgman?
Your Honor, according to the ILC report, the only information we have is that he completed the residential level of care at the coach, but then did not complete IOP. So if he has, I would just need verification of that.
Okay.
The next step from residential is actually, we call it sober living. And since I went home at my mom's house, since they said it was appropriate, that's where that stops at. I was in IOP, then after I left residential, they said I completed IOP.
Go ahead.
I was in residential.
Hang on. I need to hear from her.
Sorry.
So it's my understanding that that's not really how that works, but there clearly is some kind of confusion. So I would just need verification from the coach confirming what he's saying.
Okay. Is there a recommendation from you then as far as where he needs to be? I mean, he's obviously doing well right now. We want to continue on this path, right?
Yes, sir.
But we're not going to jump steps. We're going to make sure that you get what you need. So, do we need a new assessment?
I don't think we need a new assessment. I just think we need verification of whether or not he has totally satisfied the treatment requirements with the coach, and if there is a recommendation that he continue at
some recommendation for follow-up with
Yes.
regard to these meetings or whatever, right?
Yes.
Okay, you're ordered to complete that. Okay. Are you on med management as well?
Have you taken any medicine? Oh, yes, I'm sorry.
All right, you're ordered to comply with your medication management. There's a $205 reimbursement to the Lebanon Police Department. You have 5 days jail time credit, but I think that's all assigned to 42819, if I'm not mistaken. 0 days jail time credit on 42601. Mr. Harris, did I forget anything?
The only thing, there is reimbursement on the new case as well.
I don't have any information on that.
Okay.
What is that?
It's 205.
To who?
Lebanon Police Department.
All right, that'll be ordered. Oh, yeah. All right, Mr. Getty, is there anything else, sir?
Nothing. Thank you, Judge.
Mr. Fields, do you understand the requirements?
Yes, sir.
Okay. Your probation officer, wow. It's been a long time since I did that. I was going to call you Officer Ashley, but I didn't.
That's fine,
Well, that's
too.
not appropriate.
It's okay.
All right, so she's going to want to talk to you for a little bit after court here today, and you just need to continue on this path you started. Okay, sir?
Okay.
All right, good luck to you.
Thank you.
Mr. Harris?
Yes.
This is Judge Teep's courtroom, not Judge Otis.